Let me know when it's working.
Lets us know live.
Lovely. Okay. Good morning, everybody. Welcome back to day 2 of the inquiry into the Section 36 application for the Sanctuary Wind Farm. For anybody who was not with us yesterday,
I'm sorry, sir. I appear to be
Brown,
having a problem with the sound this morning. I've just realised.
Okay.
If you could just have
can you hear me now?
Have it resolved, hopefully.
Yeah, lovely. Okay, let's pause. Let's pause for a moment. Mr. Parkinson and Mr. Hardy, could you hear me okay?
It was breaking up slightly, but it's okay now.
And you were breaking up for me slightly too.
Okay, right. Well, it's good that it's good that we stopped when we did.
Sir,
Is that any clearer now, Mr. Brown?
No, sorry.
Alan, could you hear it? Was it breaking up for you?
It was breaking up slightly, but it seems to be okay now. I think it might be a problem on Mr. Brown's end with his audio.
Okay.
But I'll just see if they're able to get that resolved.
Yeah, that's fine. Thanks.
Sir, can I check that you can hear me?
Yes, I can
sorry,
hear
I
you
still
clearly,
can't hear
Mr.
you.
Brown.
We're trying to resolve the problem immediately. I'm sorry about
No problem.
this.
No, don't worry. It's, as I said yesterday, it's one of those things, unfortunately, with the virtual proceedings. So it looks like Mr. Brown has left and is going to rejoin us, which turning off and on again usually works. So we shall see. Mr. Brown, I can see that you've rejoined the meeting. Can you hear me?
Yes, sir, I can hear you. Had to reboot the computer. It's as simple as that. I'm very sorry about the delay.
No, not at all. No need to apologise at all. It is one of those things. It probably will happen to us all during the course of the next 3 weeks at some point. So don't worry. Okay. If you can all hear me clearly now, I shall start. I shall start again because I'm not sure how much you were able to pick up. We'd only just started. So this is day 2 of the inquiry into the Section 36 application for the Sanctuary Wind Farm. For anybody who was not with us yesterday, my name's Christopher Warren. I'm a reporter from the Scottish Government's Planning and Environmental Appeals Division, the DPEA, and I've been appointed by Scottish ministers to conduct this inquiry. So this session's being live streamed on the DPA webcast site, and a recording of each day's proceedings will also be available to be viewed there. So by way of a very brief recap, yesterday morning I explained what could be expected over the next three weeks, including the order of sessions and evidence. We then began inquiry session 1, where we've heard evidence from the applicant's first witness, Mr. Parkinson, on aviation radar and systems. Mr. Brown completed his cross-examination before we finished for the day yesterday. So we'll begin today with my questions for Mr. Parkinson, followed by any re-examination which Mr. Hardy may wish to lead. We'll then go on to hear evidence, hopefully from both the applicant's second and third witnesses today. That's Mr. Thompson and Mr. Bell, but we'll see how where the time takes us. We'll aim to have a morning break at around 11 AM. I don't think I need to say anything more now. Does anybody have any questions before we move on? Oh, okay. Good morning, Mr. Parkinson. Are you ready for us to make a start?
Morning, sir. Yes, I am.
Okay, lovely. Okay, so I've only got about six questions for you. You answered quite a few of my questions as we made progress yesterday. So my first one, I appreciate how you answered Mr. Brown yesterday, and you didn't want to speculate on potential impacts that you haven't identified yourself. So without prejudice to your position that the evidence shows that mitigation beyond what's been defined in the applicant's proposed condition would be unnecessary, a concern of GPA is effectively what happens if your predictions or the evidence is wrong. So kind of who picks up the baton in that circumstance? Is it reasonable to expect the applicant to deal with the consequences if the worst was to happen and there are demonstrable operational impacts on the airport from Sanka 2?
So, I mean, it would obviously depend on the result of that assessment, and the scope of that impact. So, I mean, if you were taking the hypothetical sort of position in the future that you did demonstrate an impact, and it was linked back specifically to the proposed development, I guess in that context, that it would be reasonable to discuss that with the developer in that sense. But as you noted, my position was based on my analysis that the evidence suggests that from my point of view, the risk of that is extremely low.
Yeah, I do appreciate your position on it. I suppose it is to some extent it's a hypothetical question, but it's a real concern of GPA. Hence why I'm asking the question. And I suppose my question would then extend to whether or not the condition proposed by the applicant should or needs to extend to cover the unlikely event in your evidence of there being a ongoing impact or some kind of impact that wasn't predicted despite the best evidence available. There's that concern there, and does that potential liability, for want of a better word, does that get reflected in the condition as proposed? I'm mindful of asking this question that we do have a conditions hearing, and Mr. Bell as well it will give evidence that relates, I suspect, to the condition. But I'd like your view on it, if I may.
So, I mean, I think my view is that it wouldn't be reasonable to put a condition on now based on the level of risk that, in my view, there is. I mean, as I said, that there is always risk in everything we do. You can't eradicate risk entirely. So we always have to live with a level of risk and proceed. So I think, based on the level of risk, I think that of that future event happening, I don't think it would be reasonable proportionate to do that. So there's nothing that's been sort of put forward in terms of how, from the evidence even put forward by GPA, in my opinion, of why specifically the development would lead to that future risk.
Okay. Okay, thank you. So, so moving on. In terms of yours and Mr. Fido's respective calculations of the predicted probability of detection.
Yes.
So I just want to partly want to make sure I understand it correctly. So whilst the difference between your calculated sort of figures are quite marked, actually.
Yes.
My understanding is that this mainly stems from the site area that's been included within that calculation, or the number of turbines included in it. So you stated that Terma's own approach is to base the calculation on the whole wind farm area rather than just essentially like the visible turbines to the radar. Is that, I just want to check, is my understanding correct? And if so, can you point me in the direction of where that's stated by Terma? Because I haven't found that.
Yeah, sure. So it's a Terma modeling document. I can find the reference for you if you.
Take your time. No, I appreciate it.
Yeah, bear with me. I'll go to the electronic list that I have. So it's in the from the GPA core document list.
Yeah.
I will find it. So it's reference CD 1930.
Okay.
So what you described isn't quite correct. So,
okay.
So it's true in your understanding of our approaches. We took the entire wind farm, and actually took then a 1 nautical mile buffer around it. So that would be wind turbines in line of sight and out of line of sight. In the Terma modeling approach, they have only taken the turbines in line of sight, but with I think it's a 2.5 nautical mile buffer around each turbine.
Okay.
And there's a nice picture in the document that kind of illustrates that. Try and find the page for you. So, for example, it's page 14. So it has a picture, and so that calculation was done for 2 nearby wind farms that exist already. In fact, their calculation, they come up with the overall, as I said, reduction factor is something like less than 1%, which is even less than the one that we came up with.
Okay, that's helpful. I'm glad I asked. Okay, thank you. So, you also said that Mr. Fido's calculation took 90% probability of detection as, I think, essentially as a sort of a baseline figure before accounting for any reduction. What does Terma say on this matter? How do they calculate it?
So they would rely on the baseline flight trial. So it would be based on the data of the actual performance of the radar in the environment at the moment.
Okay. And you said that Terma would need to make this calculation for Sanka 2, and there was a question mark raised by Mr. Brown over whether the applicant had agreed to cover these costs. I suspect you're probably not in a position to give me an update on that point, on the basis that you haven't been able to communicate with colleagues, but it's something I'll need to pick up. Okay, so on a different matter, are there any implications of microsighting of the turbines for the current sort of modelling predictions? So, is there any potential that this could invalidate the findings of the modelling that has taken place? The applicant's proposing, as you'll be aware, 100-metre microsighting allowance. Now that's being challenged by some parties, but notwithstanding that, I'd like to understand whether or not there are any implications potentially.
I'm sorry, so I'm not sure I understand what you mean by microsighting.
Okay, apologies. So it's quite normal when a wind farm is consented.
Okay.
the developer would have an allowance of, so there's a particular position proposed for the actual turbine base, and they would be permitted to basically move it a certain distance from that center point in any direction or directions specified in a condition. So they have the sort of pinpoint location and coordinates as shown on the plans that have been submitted, and then they, if it was consented and if they had a micrositing allowance as a condition of consent, they could then move that turbine base and obviously the blades above it by up to 100 meters, as is requested by the applicant in this case. But it could be less, obviously.
I understand. So I think as long as Termo are made aware of that possibility in the modelling, I guess it's at what point they do the modelling relative to obviously that final decision in where the wind farm, the wind turbines will be located. But I think if they're made aware of that, if you like, uncertainty in where the final location will be, then that's something they could take into account as part of the assessment, just to see if it would affect the final results or where particular micrositing might have an impact on the final results.
And in terms of your own findings to date, does it raise any concerns for you at all in terms of potential implications?
No, I don't think it doesn't make a material difference to the conclusions that I've made already.
Okay, thank you. Okay, so in paragraph 9.4 of your inquiry report, you've outlined the requirements for operational coverage volume of an ILS.
Yes.
And this identifies exceptions to the normal requirements. The words used are where topographical features dictate or operational requirements permit. My first question is kind of what's meant by operational requirements in that context, and then also following on from that, who decides whether operational requirements would permit reduced coverage?
So in terms of so the requirements from the document that's referenced in 9.4 are the, if you like, the maximum, well, the technical coverage that was sort of recommended. I understand, I think that's partly historical in that you may get airports where ILS is the only navigation aid, and therefore you do want the coverage, obviously as far as possible to aid aircraft in navigating to the runway. Now, I think that's unusual or wouldn't be found at all within the UK. I mean, it might be found kind of around the world. And as I said, in terms of discussion with sort of pilot contacts in terms of how they'd actually use the ILS, that, as I said, their response was that they wouldn't typically look to be beginning to acquire the signal until they were 18 nautical miles. So I think in terms of the operational requirements, you are looking at the air traffic service provider in conjunction with pilots in terms of understanding how they actually use the ILS, and that would be made reference to you'd make reference to the procedures that are defined, and those procedures are published in the Glasgow Prospects Aeronautical Information publication, and that's what I used as reference in terms of doing my assessment on the use of the ILS. I think, as I said, even though I referenced that as you can reduce the declared operational coverage down to 18 nautical miles under those considerations, that my assessment is that the wind farm wouldn't impact the 25 nautical mile coverage that they appear to be getting at the moment.
Thank you. And just to finish off on that point, just so I completely understand it. So if coverage for the ILS is expected to normally extend to 25 nautical miles in the ICAO document,
yep,
why is the safeguarded area specified in CAP 670 less than this? I think that's specified up to 34 kilometres or 18.4 nautical miles for ILS approaches.
It's a good question. My reading of that is that 34 kilometres actually aligns very closely to the 18 nautical miles. So again, for me, in analysing it, it was an indication that it's typically, the ILS typically wouldn't be used, acquired, an aircraft wouldn't typically acquire the ILS signal beyond that. There certainly wouldn't be a particular operational need to acquire the ILS signals at those ranges.
Thank you, Mr. Parkinson. I don't have any more questions. So, Mr. Hardy, would you like to offer any re-examination?
As I indicated yesterday, I have no re-examination, nothing coming from your questions either, sir. So, no, I won't be re-examining this witness. Thank you.
Okay, thank you, Mr. Hardy. Thank you, Mr. Parkinson.
Thank you, sir.
Okay, so we shall move straight on to Mr. Hardy. If you'd like to call your second witness, please.
Yes,
Mr. Thompson.
I wonder if just between witnesses we could take a 5-minute break just so papers and so on are sorted. That would be good.
That's absolutely fine. Yeah, that would actually help me as well. So if we can reconvene at 9:55, please.
Thank you very much.
Thank you. Mr. Brown, before we start, can I just check, was the audio okay for you whilst I was asking questions?
Yes, it worked perfectly. The reboot boot cured the problem, whatever it was.
Okay, excellent. Thank you. Okay, Mr. Hardy, whenever you're ready, thank you.
Thank you very much. And I'm just waiting for Mr. Thompson to come on.
Is he dialing in himself, or is he on
He's
a
dialing in him? No, he is dialing in himself. Such are the joys of technology. I wonder if I could just take 30 seconds to ask my client what's happened.
Yep, no problem. No problem.
Thank you very much. Good. Thank you very much. So I think that Mr. Thompson was being, I think he was in the holding pen and was waiting to be let in, but they've deemed him fit and competent to come in, so that is good. Right. So just I don't want to embarrass myself with pronunciation, but in your recognition, it's Daffith Rees Thompson. I've known you as Rees Thompson. What is your preferred name, Mr. Thompson? Can you hear me, Mr. Thompson? Mr. Thompson, are you there?
I've got real feedback here. Sorry.
Can you at least hear me?
Yeah, I can hear you.
Okay, that's as long as you can hear me. We'll try and make some progress. So I was just asking Mr. Thompson. I know you as Rees Thompson, but in your recognition, you're Daffith Rees Thompson. Could you just clarify which name you prefer?
Mr. Hardy, would you
I tell
like
you, yes, I tell you, shall we just take a short break, sir? Can I don't know what you were going to suggest, but take a short break and try and get the technology sorted, because
Yes, I think that would be wise. It looks like Mr. Thompson sat in the same seat as Mr. Parkinson was. Is that right?
Yes.
So hopefully there's no major issue there, because it was working well a few moments ago. So
I think that's with a different computer. Yes, but we'll try and work the IT out. If that, I'm very sorry for the glitch.
Don't worry. No, as I said before, it's one of those things with these kinds of procedures. So if you'd like to take, well, I don't want to rush you too much. So if
5 minutes. Let's try 5 minutes. I think.
We'll try 5. Yeah,
yes.
And if not, then we'll think about how long we need. Okay.
All right.
Lovely.
Thank you.
Hello, Mr. Thompson. Can you hear me?
I can hear you loud and clear, sir.
That sounds promising. Excellent. Okay.
Good. I think the only thing that's changed, as you probably see, that Mr. Thompson is appearing with the legend of Kirsty Kelshaw. So he switched computers. So he's clearly not Kirsty Kelshaw, but it is a different laptop and it now seems to be working. So that's good.
Excellent. No, that's
Right.
fine. So yeah, whenever you're ready, Mr.
Good.
Hardy,
Right.
thank you.
Let's cut to the chase then. Mr. Thompson, you have written a precognition. What we're going to do is read through that precognition first of all. And if you could pick that up, your qualifications and experience are given in section 1. So could you just read that in its entirety, please? 1.1 and 1.2.
Yep. So my name is David Rees-Thompson. I've been involved in the development, construction and financing of onshore wind farms since 2011. I'm the commercial director at Community Wind Power Limited and have worked for the applicant for nearly 8 years, prior to which I worked in the wind farm project finance team of the Cooperative Bank. As a commercial director, I'm responsible for a range of commercial matters across the business, including aviation and military planning objections. I have extensive experience in negotiating, drafting and implementing commercial agreements for the applicant. This experience includes, but is not limited to, radar mitigation solutions with aviation stakeholders, including Glasgow Prestwick Airport, NAT and the Ministry of Defence for a number of the applicants operating wind farms across Scotland.
Thank you. And a second section, commercial leverage by GPA. Could you read that?
The applicant entirely accepts the principle that safety in the area is of paramount importance. However, that principle does not allow Glasgow Prestwick to make unspecified and unsubstantiated demands on wind farm developers. The applicant similarly accepts that the proposed development should mitigate adverse impacts related to the proposed development. However, the requirement for and cost of such mitigation must be demonstrated and must be referable to the proposed development in a sensible way. I'm not a technical expert in functionality of the Terma Scanter 4002 Terma or the technical operations of GPA assets and airspace. Those are addressed by Adam Parkinson of Aegis. As described in the Aegis assessments, CD 1329 and CD 1330, the only mitigation actions that are required by the proposed development cover 1, formal modelling of the predicted probability of detection by Terma, 2, optimization of the Terma for the proposed development, and 3, an assessment of the performance of the Terma once a proposed development is built, typically using a flight trial, to verify it is meeting GPA's operational requirements. Aegis has estimated that these costs will be no more than £60,000. I'm aware of an open exchange of email correspondence, app 0222, between GPA solicitors Pinson Masons and the applicant solicitors Cameron McKenna, which sets out the proposed costs that would be payable under the previous versions of GPA's Wind Farm Mitigation Agreement, WMA. A new form of commercial agreement has been referenced by GPA, to which I turn below. Pursuant to the previous WMA, the proposed rates can only be described as a turbine tax, with £38,000 per megawatt payable for the first 50 megawatts, and with a discount to £28,500 per megawatt offered for any capacity above that. Based on GPA's assertion that 15 turbines of 7 megawatts are visible, the payment under this mechanism from the applicant would have been approximately £3,467,500. I'm not aware of the specific mitigation that GPA was proposing in 2019 to deploy for the sums requested at that time, but these sums are very considerably in excess of the cost calculated in the Aegis report for the mitigation which is referable to the proposed development. Calculation on a per megawatt basis is not a rational way of calculating the cost of mitigating any impacts from a wind farm. A turbine of 200 metres to tip, with a rotor of 150 metres, will have exactly the same impact on GPA's radar whether its internal generator is 2 megawatts or 4 megawatts. Despite being exactly the same physical size and shape, and therefore producing exactly the same radar impact, the pricing approach of GPA would result in the turbine with the larger generator paying double the mitigation costs of the turbine with the smaller generator. The applicant's position is that the sums required by GPA under the previous WMA bore no relation to the actual cost of mitigation required to accommodate the proposed development and were wholly unreasonable. Rather, they reflect GPA's commercial approach to wind farm development and GPA's expectation to receive substantial and unsubstantiated payments as a commercial income stream rather than a mitigation actually referable to the impact of any proposed development. That is not a legitimate basis on which to receive payments under the Scottish land use consenting regime, and it is unjustified that the applicant should be subject to GPA securing a very significant commercial profit through leveraging its position as a statutory consultee. I'm aware that GPA procured the wind farm tolerant term of radar in 2016. I oversaw the contribution agreement entered into by affiliate of the applicant, which involved contribution towards the implementation costs of the term at GPA. From publicly available accounts, AP 0211, AP 0212, and AP 0213, it is known that the GPA has already received approximately 8.2 million from wind farm developers as of 31st March 2020, and that this is at least £2 million in excess of the capital expenditure made by GPA in respect of the implementation of the term. The applicant has confirmed its willingness to enter into an obligation to meet the demonstrable costs of optimisation and testing identified in the radar report as arising from the proposed development. These costs have been calculated by the applicant to be approximately £60,000.
Thank you very much. And then you turn to non-disclosure. So section 3, please.
The applicant confirmed its willingness to meet the reasonable costs of the limited mitigation by letter of 30th July 2021. The applicant has not received any response from GPA to offer it to pay for those costs for the costs identified in the Aegis report. The applicant has also advised GPA that it would be willing to consider a response received on a without prejudice basis, but has still not received a response. Instead, GPA has insisted and continues to insist that the applicant must enter into its WMA, having first entered into a non-disclosure agreement, an NDA. Only once a WMA is signed does GPA truly engage with the wind farm developer to identify and seek to resolve any purported impacts. GPA will not disclose the terms of the WMA, any purported changes to the proposed costs and charging mechanism indicated above, or identify what mitigation it includes without the applicant having signed an NDA. In other words, it is a closed system. The land use consenting process is a public process designed so that all parties, including the Scottish ministers as a decision maker, can understand what is going on. It's wholly unreasonable behaviour on part of GPA to be unwilling to discuss mitigation and costings in an open and transparent way. As referenced above, a new form of commercial agreement and charging structure has recently been intimated by GPA. GPA's agents describe this purported new position as mutually beneficial to both parties. However, GPA remains dogged in its insistence that it will not discuss or disclose any new terms in the WMA whilst the applicant has not signed the NDA. As a result of GPA's demands that the NDA be entered into prior to disclosure of any new terms and discussion of them, and the applicant's unwillingness to accept this approach as appropriate to a public consenting regime, there is no way of being able to assess the validity of this statement. It may well be that the applicant would consider the revised terms are even more injurious. GPA faces a major difficulty in this process if it refuses to identify what mitigation it says is required, how that would be referable to the proposed development, and how much it would be cost. Without evidence of the same being given to the inquiry in an open and transparent manner, I'm advised that neither the reporter nor the Scottish ministers will be able to rationally conclude that mitigation sought by GPA passes a test of lawfulness for a condition or legal obligation. It appears that the reason GPA will not do so is because in recent years, GPA has relied for a large percentage of its income stream on the willingness of wind farm developers, in the face of an objection from GPA, to pay massive sums of money for the objection to go away. The reality is that GPA needs to protect its closed system as fiercely as it can, because if it had to justify its charging system in a public forum, it could never do so. If this was not the case, then there can be no reason why GPA will not have an open discussion during this inquiry. In the open correspondence set out above, GPA has disclosed the costs it was seeking under the previous WMA, and the applicant is unable to see a legitimate reason why it would not be prepared to do the same now.
And then section 4, your conclusion briefly.
The applicant's proposed mitigation, which is reasonable, is to meet the specific and identifiable costs of testing and adaptations flowing from the proposed development as set out in the Aegis report being no more than £60,000. Notwithstanding multiple attempts to engage with GPA on an open and transparent basis, GPA has maintained its position that it will not disclose what mitigation it says is required, how that would be referable to the proposed development, or what it would cost unless the applicant signs an NDA. No mitigation over and above that proposed by the applicant is required. GPA is simply not in a position to argue for anything more if it is not prepared to reveal the contents of its WMA and charging mechanism to the reporter and the Scottish ministers and allow it to be the subject of debate in the public arena.
Thank you very much. Now, by way of amplification, I've got 15 mercifully short questions and topics I want to deal with, which have arisen post-recognition. The first of those really goes back to the introduction and qualifications section. Mr. Thompson, you indicate your role is a wide-ranging one. I just want to understand the degree to which you negotiate and draft commercial agreements of the sort that that would be in play here.
Yeah, so as I set out in my precognition, my role is a wide-ranging one. My principal tasks within the business are the negotiation and drafting of commercial agreements. That involves the drafting of aviation agreements, of which I've been involved and overseen 6 in my time at Community Wind Power, 2 contracts with the MOD, 3 with NATS, and 1 with Glasgow Prestwick.
So it's a broader portfolio of commercial agreements, but within that, then 6 of those have been aviation agreements. Is that right?
That's correct.
Okay. Second question then is your involvement with GPA on this project. So project-specific involvement with the airport is what?
So I've been involved with the Glasgow Prestwick objection on the proposed development since the very beginning. As a result of the refusal to progress the dialogue without having signed the NDA, I am afraid that the dialogue has been less than we would have hoped.
Okay, well, following on from that, really the third point, and by way of comparison with those other aviation agreements that you've negotiated, well, indeed, any of the commercial doesn't need to be restricted to aviation agreements. How do you describe the approach of GPA in contrast to those other organisations?
Well, it's somewhat different to the approach of GPA back in the day. There's other aviation stakeholders have had a much more open and engaging approach to mitigation requirements. That applies to both NATS and the MOD, where there's been an effort to resolve the objection rather than a sort of refusal to engage without signing up to non-disclosure obligations, as is the case here.
You say back in the day. That's an interesting phrase. What do you mean by that?
Well, obviously, in 2016 and well, even earlier, there were outstanding objections from Glasgow Prestwick to a number of wind farm applications. It was recognised that a wind farm tolerant radar would be required to overcome those, and GPA engaged proactively with developers to procure that wind farm tolerant radar, and the wind farm developers provided towards the capital cost of installing that.
Okay, and in terms of the approach taken by GPA at that time, so back in the day, as you put it, was that consistent or inconsistent with what you'd seen with other stakeholders on other schemes?
That was consistent with what we'd seen with other stakeholders, whereby if a wind farm tolerant radar was required, then either a single developer or a club of developers would meet the capital costs of installing such wind farm tolerant radar in order to overcome the relevant objection.
In the list that you gave of the 6 contracts, I think you said 2 with the MOD, true, and that's one with Glasgow Prestwick Airport. So when you're comparing that back in the day, as you put it, the reasonableness, was that with a civil aviation operator, or was that with an airport?
So that was with a, well, aside from the specific instance of Glasgow Prestwick, which I mentioned, that applied to both NATS and to the MOD.
Thank you very much. All right, let's move on. Next topic is, and this is bearing in mind that Mr. David Bell, as you know, the planning consultant, is going to be giving evidence later, probably this morning, and of course there are legal submissions as well. But so far as your knowledge is concerned, as the contract negotiator, what's your understanding of the basis for a planning condition or a legal obligation if it is to be lawful?
Well, as you point out, I'm not a lawyer. I'm neither a lawyer nor a professional planner. So Mr. Bell is perhaps better placed than I to answer that. But my understanding, based on my experience, is that the any condition or legal obligation would need to meet the 6 tests as set out in the circular. And if it didn't meet those tests, then it wouldn't be lawful.
Okay, so that's sort of working knowledge, but the detail of those questions to be put to Mr. Bell. And I suppose the next question relates to technical evidence. To what extent do you rely on or not on Aegis and the expert evidence that's been given by Mr. Parkinson? So putting it another way, have you undertaken your own assessment or costing exercise yourself?
Well, we're not technical experts in radar schemes or radars as assets in themselves. We rely on technical evidence from Aegis when assessing any aviation objection. Whilst I have experience of aviation objections, and I have experience of the costs that are associated with different types of objection, we do rely on the advice that we receive from technical experts when assessing these positions. Okay, so well, Mr. Parkinson's been, and GPA's had its chance there, and Mr. Bell is to come. So that's a neat explanation of the evidence. Right, 7th question I've got for you is, you deal with the previous wind farm mitigation agreement. I'm just interested in you telling the reporter how you came across those terms, and what were they? What observations do you have on them? So these are the terms previously disclosed to us by Glasgow Prestwick?
Yes.
In relation to Sanka 2 or in relation to previous?
In relation to Sanka 2, yeah.
Yeah. So the previous proposal was for a capital contribution of £38,000 a megawatt, as set out in my precognition, with a discount to £28,500 a megawatt thereafter. So my view is that those are unreasonable because they relate to, as I said in my precognition, they relate to the generating capacity or the nameplate capacity of a wind farm, and not the actual planning impact that is being seen. So the example I gave was that a turbine of 200 meters to tip with a rotor of 150 meters has exactly the same aviation impact, regardless of whether the generator is a 2 megawatt generator, a 4 megawatt generator, a 6 megawatt generator. The structure is the same. The impact to the radar, as far as I understand it, not being a technical expert, is the same. But the pricing structure, notwithstanding the discount for buying in bulk, prejudices the generator, the turbine with the highest generating capacity. I can't, as I can't see any reason for that to be a justifiable costing mechanism.
Okay, well, that's the detail, if you like, of the costing. But I'm interested for a second in the point of principle, because timing-wise, you'd indicated that GPA had already met the capital cost, the capex cost of a wind farm tolerant radar. Was it after that purchase, or was it before that purchase, that it was asking developers to continue to pay contributions?
It was after that purchase, so the capital costs for installation of the radar had already been recovered from an original cohort of developers that had contributed towards the capex costs associated with installing the terma and the associated technical requirements, MRT and the like.
I suppose one option would have been for the airport to redistribute that capital. So the capex contributions that it had received, it could have redistributed that capital to the historic radar contributors. So far as you're aware, is that what was being done or not? Or was it keeping it?
Not as far as I'm aware. My understanding is that the £38,000 a megawatt cost was being retained by Glasgow Prestwick. It wasn't being redistributed to the original contributors, which has happened in other aviation solutions elsewhere. But my understanding was this is to be retained by Prestwick.
Okay, so if that's right, the capex costs of the mitigation solution had already been spent. They weren't going to be redistributed or paid back to the historic contributing parties. On what basis was the money being retained by GPA?
I can only presume that it's retained as profit.
Thank you. Obviously, you've referred to the accounts, and we'll go there in a little bit. The ninth question that I've got for you in relation to the bargaining power, if you like, so strength of arms in the commercial negotiation. What room was there? Or was there any room for negotiation by the developer, or is it a case? Well, you tell us how that equality of arms worked itself out.
Well, that there is none. This isn't a normal procurement or tendering process. In other commercial contracts within the business and the group, there are alternative providers. So in the event you receive unfair commercial terms or contractual terms from a counterparty, you're able and entitled to seek alternatives. In this instance, the objection is a statutory one by a consultee in a statutory process. There are no alternative providers which we can resort to in the event that we are unable to accept the terms being proposed by GPA. So, yeah, the control seems to be vested with Prestwick in this process.
Sometimes in commercial negotiations, there might be reference to third parties or arbitration or that sort of thing. But in your experience, who was the arbiter of the price?
Well, there isn't one out with this process. I know it's intimated in the Clauchrie inquiry that the CAA might be an arbiter of that process, but I'm not aware of any framework in which that arbitration could take place. My understanding, based on my experience of statutory planning processes, that this is the relevant forum to be airing this debate.
What about bargaining power from different developers or different size schemes? So far as you were aware, could one developer with better bargaining power perhaps end up with a different result? Do you know?
I don't believe so, and I think that's probably fairly well demonstrated by the approach taken in the Clauchrie inquiry. Obviously, a competitor of ours with its own bargaining strengths found itself in the same position. So I think that's probably the best evidence we can give.
Okay, well, let's just pick up them 2 points really coming out of the Clauchrie inquiry. Of course, the cross-examination transcripts are there in full, and we'll go to those later on in cross-examination. But the accounts submitted by GPA, you've looked at those?
I have, yeah.
What do they show in your view in terms of costs of the radar and income so far received?
Well, they show the cost of the radar being recovered from 2017 onwards. They show that the total amount recovered to date is £8.2 million. I think it's actually £8.147 million. But and that I understand it to be approximately £2 million more than the cost of the whole mitigation solution, comprising the wind farm tolerant thermoscanter, radar, MRT, and associated actions.
Now, I know there was some debate at Clauchrie about whether or not it was they were appropriately titled wind farm service payments, and I think that the airport was saying that perhaps that was a bit of a misnomer. But I'm interested more in the substance of that. What comments do you have on the way the airport's finances were or have been dependent on those wind farm service payments, or whatever we want to call them?
Well, it's obviously a substantial income stream for the airport, and I'd imagine that going forward they consider this to be a nice income line in future forecasts of profitability.
Okay. Question then 11, really, from the Clauchrie cross-examination notes. I've said I'll be going to the cross-examination. Is there anything that you want to raise, even as in a thematic way, for the reporter at this stage, just to flag up what we might be looking at?
Well, obviously, it's noted in the Clauchrie inquiry that the mitigation costs have changed from a capital contribution to an annual OPEX contribution in the inquiry evidence of Mr. Kilpatrick. And we would consider that to be even more unreasonable than your requirement to make a capital cost contribution on day one. So that's probably my main observation from the Clauchrie evidence.
Okay. Let's move on then to non-disclosure. And I'm interested in you just explaining why CWL has elected not to sign the NDA and know the terms on which the WMA was being offered. So, putting another way, there seems to be a point of principle which came out in your evidence in chief, and that is a point about openness in public proceedings. You seem to take that very seriously, and I want to just for you to explain on behalf of the applicant why that is.
Obviously, our position is that the planning process is one that's set out in statute. It's a public process. Prestwick are consulted as part of that process in the way that other consultees are. The position of Glasgow Prestwick in relation to that process is no different to the position of other statutory consultees. In the event that there are objections that the applicant requires to overcome, and is not able to do so in dialogue with the consultee, then the correct framework for addressing any outstanding objection is this public inquiry process with the DPA. So so the Scottish ministers are able to receive all of the information pertinent to the application, and so as reporter, you're able to hear evidence and form a position in relation to the outstanding objection.
In terms of being able to have an open discussion at this inquiry session, bearing in mind, I think you said that it's a closed system and things can't be discussed. If that had been signed prior to evidence, what position or how would that, in your view, have impacted on CWL's ability to come to this inquiry?
Well, we wouldn't have been able to. If we'd signed up to a non-disclosure agreement, then the terms of that would have prohibited us from having this conversation now, without being in breach of contractual bilateral agreement between us and Glasgow Prestwick, which would obviously come with remedies in law, including potentially damages. So it's not a position that we could enter into. Or any reasonable applicant in a planning process could enter into. Our view is that the correct forum for this dialogue, for this discussion, is here, and we didn't want to prejudice our ability to have the conversation.
We'll see in due course whether GPA takes a different position to the firm one it took at Clauchrie, where it said, look, we're just not going to tell anybody what the costs are. We'll see what happens here. But what GPA, of course, has said is that the old agreement that you've been talking about has been done away with. There's a new set of there's a new mechanism, and what it says is, look, the revised terms are more beneficial to both the airport and to CWL. I'm just interested in that. You're a commercial contracts negotiator, contract that's better for both parties. What do you think of that?
Well, it's, to me, it seems like a bit of an oxymoron. I fail to see how a contract can be, any improvement can be better for both parties. It's a new one on me.
I think that's all that I need to ask about NDA. In terms of the actual costs, I mean, what we said is, look, you had the opportunity to know what this is going to cost, but you have turned your face. You don't, you said we've given the opportunity. You don't want to know. You said, well, that's not fair because it's a closed system, all right. But have you any idea of what is now being charged by GPA?
All I have is supposition based on the evidence given at Clauchrie. I understand it to be an annual OPEX payment, which in my view would be more injurious than a single capital cost. And again, based on the evidence of Aegis, less relatable to the proposed development. There's no operating costs identified by Aegis, so just can't see that that's justifiable.
Okay, I mean, you just say hearsay, and if that's what it is, that's your description. I guess, has there been anything firmer than that? Has there been anything at all, just so the reporter is clear of the position, has there been anything openly discussed with GPA, or that they've been prepared to give about either the charges or indeed the underlying mechanism for that charging?
No, as far as I'm aware, the only cost that we've received from GPA are the pounds per megawatt charging structure. I have here say that the new structure comprising the operating cost is also pounds per megawatt, but it's just hearsay.
Well, you're not the lawyer, you're not the planner, but bearing in mind your commercial experience, I want to know to what extent you consider that to be reasonable or unreasonable for GPA to come to this inquiry, asking this reporter to require your employer, CWL, to sign up to a mitigation strategy which you say is opaque and open-ended and which it won't discuss in public.
I don't think it would be reasonable based on the evidence of the technical evidence of Aegis, my understanding of the 6 tests contained in the circular, and the actual impact that the proposed development will have on Glasgow Prestwick Airport. I don't think it'd be reasonable to provide for us to become liable for either a one-off capital cost or a pounds per megawatt operating cost that is completely disassociated with any technical requirement for mitigation. My view is that that wouldn't be a reasonable approach to take.
Okay, thank you very much for that. Now I want to move to the table of risk and costs, which has come up a lot. I think we spent an hour and a half or whatever it was yesterday going through the various elements of that. We probably don't need to go through all of those individual segments again, because I hope we can take it more thematically, Mr. Thompson. But you've seen that table of cost and risk, have you?
I have, yeah.
Yeah. I'm interested in your observations on it and whether what you make of it. Yeah.
Obviously, Adam Parkinson of Aegis has spoken to the technical and operational risks. His view that a number of those risks are just generic business operating risks associated with being a commercial airport and not related to the proposed development. I would share that view. I would probably have a couple of further observations. The initial costs and risks apply whether an application proceeds or not, is withdrawn or not, is approved or refused. then they are just general activities associated with a role as a statutory consultee. The cumulative effects obviously were discussed at length with Mr. Parkinson yesterday, and I fully agree with the position he set out there. And I guess my final conclusion would be that we're looking 15-20 years into the future when there might or might not be drones flying around delivering parcels is not it's not a rational argument to bring to a planning inquiry, in my view.
Thank you very much. Now, point 15, question 15 really arises from what the one of the questions that the reporter put to Mr. Parkinson this morning, and that is, well, look, GPA is saying you need to apply some form of contingency, so you can't just plan for the sunny day, everything going as you want it to, but what happens if it rains? And so I'm interested in your view on that. Why is CWL not prepared to pay for a contingency in the event that the tests don't go in the way you hope? Is that reasonable?
Obviously, the evidence of Mr. Parkinson is that the mitigation steps that we proposed will provide mitigation for the wind farm. So, this is a contingent scenario that doesn't really need to be considered. I think Mr. Parkinson also gave evidence that there is risk in every aspect of life, and you can never remove risk from anything, but it's proportionality and reasonableness. And his view as technical expert is that there is no requirement to provide for a contingency measure in this particular circumstance, faced with the technical asset, its ability to mitigate the proposed development once the steps have been undertaken, and its inherent wind farm tolerance. The contingent scenario, just in his view, didn't exist. And as I set out, we're not radar experts, so we rely on the advice of our technical experts.
Thank you. Well, I'll also pick that up in chief with Mr. Bell in due course. Then the final question I've got for you relates to the commercial evidence that was heard at Clauchrie. So not so much the so the evidence given by the GPA's commercial director. You've obviously read that. Do you want to just give a thumbnail for this reporter of the main points that you took from that?
I think my view of the approach of Glasgow Prestwick to this process is probably actually best described or best portrayed by paragraph 18 of the precognition of the commercial director of Glasgow Prestwick, where she says that the airport, just like the applicant, is a commercial organisation. That is generally true, but in this process, its role is not as a commercial organisation. Its role is as a statutory consultee in a planning process. Its commercial approach has no relevance to the position we find ourselves in here, and it's not entitled to take a commercial approach to wind farm mitigation requirements, in discharging its role as statutory consultee.
Thank you very much. Those are the 15 topics that I wanted to cover with you. Same as yesterday for Mr. Parkinson, opportunities or anything else that you want to add to your evidence in chief that you think I've missed or you want to particularly raise? If not, then it'll be cross-examination.
No, I mean the main point for me as a commercial director, and I don't really comprehend, is that a turbine of the same size and shape but with different generating capacities would receive an entirely it'd receive double the cost under Glasgow Prestwick's charging methodology, despite being exactly the same turbine. I can't see any rational basis for taking that pricing approach other than a commercial one. So my view is that Glasgow Prestwick has approached this process with a view to extracting as much money from the planning process for onshore wind farms as possible, and that's probably evidenced by sort of a discount structure for bigger generators. It's if a mitigation cost is a mitigation cost, it's just a cost of mitigating an impact. It doesn't change according to size or there is no difference according to the generating capacity of the turbine. It is just the impact needs to be mitigated, and this is a cost associated with it. And that's probably to some extent also applicable to refusal to disclose updated commercial terms without a non-disclosure agreement, because potentially that prejudices the confidentiality obligations that have been given elsewhere. We're not asking Glasgow Prestwick to disclose, terms that have been entered into with other wind farm developers in respect of mitigation requirements for other wind farms. We're only interested in the mitigation costs associated with the proposed development, and those particular mitigation costs, which we consider must be applicable only to the proposed development and not associated with any other wind farms, and therefore unaffected by confidentiality obligations elsewhere.
Thank you very much, Mr. Thompson. Then with that, so that's evidence in chief. Thank you.
Thank you, Mr. Hardy. Thank you, Mr. Thompson. Mr. Brown, before we begin cross-examination, I might suggest, rather than interrupt you shortly after you've started, it might be wise for us to have a comfort break now. How long would you estimate cross-examination lasting, Mr. Brown? I won't hold you to it precisely.
At least an hour, I would have thought, sir.
Yeah, okay, no, that's fine. Well, I think let's take a break now, and then we'll look to run through till lunchtime with your cross-examination. So if you could ask us to break now until 11 a.m, please, and we'll start then. Thank you.
Yep.
So Mr. Thompson, you weren't on the call yesterday, possibly. Please, if you can just not be in conversation with any of your colleagues during the break, you can turn your video off and your audio and your microphone off, but please don't leave the call, because it will take you some time to rejoin. Okay, thank you.
Thank you very much, sir. Thank you.
Okay, welcome back, everybody. Mr. Brown, whenever you're ready, thank you.
Thank you, sir. Mr. Thompson, good morning.
Morning.
Mr. Thompson, the airport is obviously here, as you had said, as a consultee. Do you accept that the reason why it's here as a consultee is because a wind farm development might have an impact on the airspace in which the airport or an airport provides air traffic services?
I accept that's why it is involved in the planning process. I don't accept that it's here because the wind farm has an impact on it. I think that's probably the point where we disagree. Mr. Parkinson's evidence yesterday was that the wind farm tolerant radar at Prestwick means that the mitigation requirements were insufficient to cause the level of impact which Prestwick maintains.
Well, would you accept that that's a matter for the inquiry to determine the level of impact?
Of course, I'm not a radar expert. I'm just...
And my question was actually that the airport is here as a consultee because it's recognised, let me put it this way, it's recognised that wind farm developments have potential to adversely affect the airspace in which an airport provides air traffic services.
They have the potential to.
And in paragraph 2.2 of your recognition, you accept that the applicant recognises that the proposed development should mitigate the adverse impacts related to the proposed development.
Yes.
Now, do you also accept that once mitigation has taken place or has been put in place, that that mitigation will have to remain in place for the lifetime of your proposed development?
Once the mitigation is in place, if it mitigates the proposed development, then it will cover it for the lifetime of the wind farm.
Is that correct?
The mitigation.
Well, what if when we get to a point where the thermal radar, for example, reaches the end of its operational life?
I think this point was addressed by Mr. Parkinson in evidence yesterday that replacement of radar is just a general commercial risk of commercial and operational activity of running an airport.
And you would say that so, notwithstanding the fact that any additional requirement imposed upon the airport to mitigate your development arises as a result of your operations?
Again, this was addressed by Mr. Parkinson in his evidence yesterday that the wind farm would form part of the environment that the replacement of the radar would have to be optimized for at the time it was installed. But that's again part of the operational activities of a commercial airport. In the same way that I think Mr. Parkinson described hills as forming part of the clutter that a radar would see on commissioning and requiring optimization to address.
But is the difference with the hill not that it's a static object? It's not like a wind turbine which rotates in the wind?
I think again, I'm not a radar expert, so this is just my understanding of it. But they both produce clutter, which is obviously the thermoscanter is inherently wind farm tolerant and is inherently able to remove clutter arising from wind farms. So that's why it was procured. If that answers your question.
Yes, but as you've acknowledged, you're not a radar expert, so you don't actually know what, or let me ask you this, do you know what is meant by a wind farm tolerant radar?
Well, as you said, I'm not a radar expert. So in my understanding of a wind farm tolerant radar is a radar which is inherently able to remove clutter arising from the operation of wind turbines as part of its normal operation.
But you don't know what's required to ensure that it will mitigate the clutter, do you?
No, I mean, that's a technical question that I think Mr. Parkinson did pretty well at answering yesterday.
And you've said that once mitigation is provided, if and when it comes to the point when Terma has to be replaced, the airport just has to accept that clutter created by the radar into its baseline environment. Are you able to point to any publication or document which says that's the way it should happen?
Am I able to point to any publication or document that says that at the time the radar is replaced,
the airport just has to accept that into its baseline operating environment?
but that will be the baseline operating environment at the time the radar is replaced?
Yes, but I've asked you whether you can point to any document which will support your position that the airport just has to accept a wind farm into its baseline operating environment.
Well, I'm not a radar expert. I couldn't point to the any of the CAA documents to that specifically identifies that. But obviously, it is the baseline environment at the time.
Yes, so you're not able to point me in the direction of anything which says the airport has to accept that.
The baseline environment would include wind farms per se, or the proposed development. I mean, the baseline environment at the time the Terma is replaced will include wind farms. I think that's agreed between the parties.
Yes, but your position is that at that point the applicant here would have no responsibility for having created additional work which may be required to optimise the replacement Terma as a result of your wind farm.
But I think the position that was articulated yesterday was that because the baseline environment will include wind farms, it will be a wind farm environment at the time the radar is replaced. The radar that is procured to replace the Terma at that time will be a wind farm tolerant radar, because it will need to be as a result of the environment being a wind farm environment at that time.
Yes, but I think, as you've acknowledged, Mr. Thompson, you're not a radar expert, so you don't know what will be required at that point to make sure that the wind farm tolerant radar, as you describe it, will be able to mitigate the effect of, or will mitigate the effect of your proposed development.
I'm not a radar expert. The radar technical questions were addressed by Mr. Parkinson yesterday.
Okay, now in paragraph 2.3 of your recognition, you have set out there, just taking it shortly, the 3 mitigation actions as you described them which are required. And again, just for the avoidance of any doubt, when you set out these 3 mitigation actions, you are relying upon the evidence from Mr. Parkinson.
That's correct.
And you accept that it will be a matter for the inquiry to ultimately determine just how far the mitigation should go for your proposed development.
I mean, it's for the inquiry to hear evidence from the parties and determine, the extent of mitigation that is required. As I said, I'm not a radar expert. We employ Aegis as technical expert, and the advice we received was that these 3 items are the only mitigation that's necessary to accommodate the proposed development.
Now, yesterday, Mr. Thompson, Mr. Parkinson acknowledged that the airport staff would inevitably be involved in the optimisation processes to be undertaken, but he wasn't clear about whether the cost of 60,000 which he had included the cost of the staff. If it transpires that that estimate of £60,000 does not include the cost of the staff, are you prepared to accept that there would have to be a payment in respect of an additional payment in respect of the airport's time involved in providing mitigation for your development?
As far as I'm aware, the airport hasn't set out exactly what the requirements of its staff would be. The mitigations actions that we've set out are, modelling by terma, which is obviously done by terma, optimization of the terma, which again would be done by terma, and the flight trial, which I presume, although I can't be certain, would be contracted to a third party. I don't understand that Prestwick would undertake the flight trial itself.
No, obviously the airport would not undertake the flight trial, but would you not expect that the airport would have been in contact with the operator providing the flight trial to make arrangements for that to happen, for example?
I'm sure there would. I'm sure there would have to be a dialogue.
Yes, and that the airport would incur costs and so on in arranging that.
I'm not aware that the airport set out any specific cost that it would incur in undertaking these actions.
Yes. But my question is, do you accept there would be a cost?
I accept there would be some work to be done. I'm not aware of any costs that have been itemised.
And that work to be done, are you suggesting to the inquiry that the applicant would be entitled to that work without having to pay for that work?
We're not suggesting that the airport is exposed to these costs. We've set out our understanding of the costs associated with a particular scope of works that's necessary to effect the mitigation required to accommodate the proposed development. We set out these costs to the airport on a without prejudice basis, inviting a response, and we haven't received one. I don't disagree that there will be some work involved with the airport. There would have to be a dialogue with the plane that undertook the flight trial. My point is that we haven't received any indication from the airport as to what these costs might be, what work might be required on behalf of the airport. We've just put forward to this inquiry our estimate of what works are necessary, noting that the modelling work is done by terma, the optimisation work is done by terma, and our understanding is the flight trial is done by a third party.
Yes, but are you prepared to accept that in principle it's inevitable that to carry out these steps, the airport staff will have to be involved in ensuring that they are carried out?
The airport staff have had to be involved in the inquiry process. They will no doubt be involved in wind farms for many years to come. I'm not aware of any specific costs that have been set out in relation to our proposed works.
Well, in principle, are you prepared to accept that if the airport establishes that its staff will spend time and effort in procuring mitigation to accommodate your development, are you prepared to accept that in principle the applicant should pay for that time?
It depends on the nature and the extent of the works that are proposed as being necessary. I mean, we haven't seen them. They haven't been discussed. There's just a general catch-all comment that the airport is entitled to secure payment of time and cost and profit for undertaking these works, but without any specification as to what works are necessary, how much they cost, how long they would take.
Well, I specifically asked you, Mr. Thompson, about whether you would be prepared to accept in principle that there would be a liability for these costs. I appreciate that you might want later on to address the question of whether they're necessary, reasonable, and so on, but my question was at a very high level. Do you accept the principle that if airport staff are involved in ensuring that your development is mitigated, that the airport has a legitimate expectation that the applicant will pay for that?
Sorry, yeah, a bit dropped out in the middle of that.
Right, okay, sorry. Let me reframe the question. Do you accept that in principle, if the airport incurs cost of time in connection with ensuring mitigation of your development, do you accept that the applicant should pay for that? Now, I'm just asking that at a high level.
So if the cost that is incurred by the airport is demonstrable and reasonable and is in conjunction with our technical advisors, is agreed to be, related to the proposed development and reasonable, then yeah, I think that there will be an element of work required. I just don't know what it is and how much it is and the extent of it.
Yeah, certainly. And I wasn't trying to commit you to that, but I was just asking you, in principle, you recognise that there will be a cost for
I
it.
mean, I think, we've set out that the bulk of the cost, in our view, is associated with Terma modelling, Terma optimization, both of which are carried out by third party, and a flight trial, which is, as you've noted, carried out by a third party. So, I think any cost that will be from the airport will be de minimis.
But that is diverting away from my point, Mr. Thompson, because I wasn't talking to you about third-party costs. I was asking you about the cost which the airport staff will incur, or the cost of the staff in ensuring mitigation is carried out. But you accept in principle, at least, that that is a cost which the airport could expect to recover.
Yeah, I'm not sure I'd agree entirely without having, assessed the elements which I set out, the extent and scope and value associated with those, noting that, in our view and the view of our technical expert, the works to be undertaken by the airport are de minimis. Noting that the modelling and optimization will be done by Terma and the flight trial will be done by a third party.
Mr. Thompson, I recognised in an earlier question that you would want to explore those points. But my question is, as a matter of principle, without getting into the detail of it, and I accept that you would want to look at the detail of what the costs are, but I'm asking you whether, as a point of principle, you accept that the applicant should pay for the cost of the airport's staff's time in connection with obtaining mitigation for your proposed development.
Yeah, I think we're going over the same ground here, but yeah, I mean, if the airport put forward some costs which were reasonable, proportionate, related to the proposed development, and were verified by the technical expert, then that might be reasonable.
All right. Now, in paragraph 2.4 of your recognition, you refer to the fact that the airport has a new form of commercial agreement, and you then compare that to the previous discussions, and you refer to turbine tax, so as you call it, of £38,000. Now, of course, the thing is that when you make these comments, you don't actually know what is in the new form of mitigation agreement, do you?
I don't know what's in the new form of mitigation agreement because the airport won't disclose it to us without us signing an NDA, which essentially acts as a gagging agreement on having conversation in a public forum. But my understanding is that it's an ongoing OPEX cost, again priced in pounds per megawatt. And my view is that anything priced in as a pounds per megawatt structure is unjustifiable because it does not relate to the impact that any turbine application has on the airport. Because for the reasons I set out in my evidence in chief, a turbine of 200 meters to tip with a 150 meter rotor and a generator of 2 megawatts has the same planning impact as a turbine with a generator of 4 megawatts. But under the pricing structure that we've seen previously, would have double the cost for no additional impact. That's unjustifiable.
Well, would you agree, Mr. Thompson, that that's the point, that not having seen the new form of agreement, you don't know what the new form of agreement provides regarding your concern about the fact that the same size of turbine can generate different amounts of energy?
But it's just that is a planning point. If the turbine is exactly the same size and shape, there's no evidence before the inquiry that suggests it has any different impact depending on the size of the generator contained within the turbine. But the evidence that we have seen and we've proposed that we put to the inquiry, is that under the previous pricing structure would have incurred double the cost.
Yes, and Mr. Thompson, that's a point which you've put before the inquiry, but my question is, you don't know how the new form of mitigation agreement may address your concern, do you?
But the airport hasn't put any proposed terms before the inquiry. We've put what we know to be the case before the inquiry, and the airport hasn't provided any alternative pricing structure. All it's done is intimated that there is a new one, which it claims is, mutually beneficial, which, my evidence in chief, I indicated that I didn't see how a commercial contract could be mutually beneficial to both parties, when discussing a new pricing structure. Whenever there's, a price change, one party has to lose out. Someone pays more, someone pays less. So
I'm just going to ask you a straightforward question, Mr. Thompson, and it'll be a yes or no answer, I would hope. You don't know, do you, what the new agreement provides to address your concern?
I don't know, because the airport wouldn't disclose it to us without a non-disclosure agreement. All I have is the evidence from the Clauchrie inquiry, where the commercial director of Glasgow Prestwick notes that it is an annual operating payment. If you bear with me 2 seconds, I think it is in evidence, and can take you to it now if you like.
Well, I think the point there, Mr. Thompson, the Clauchrie inquiry inevitably raised different issues. You have raised this issue, which is of concern to you here. And my question was only about whether you knew what the new agreement provided.
Yeah, I think it raised some of the same issues, to be honest. But I'm just looking at the transcript of the Clauchrie inquiry. Zoe Kilpatrick answers a question: what is the definite need in this particular case for a per megawatt payment per year to be going forward? And Mr. Kilpatrick advises it's required because. So I think I can take from that that whilst I don't know the quantum that's involved, I do know that it is a pounds per megawatt per annum payment, and for the reasons I've set out, that is not reasonable or justifiable or rational. And there's no evidence that I've seen before this inquiry that would lead me to change my mind on that.
Yes, but you accept, Mr. Thompson, that not all of the issues which you have chosen to put before the inquiry here were raised in the Clauchrie inquiry. And I was at the Clauchrie inquiry, and there was no mention of this issue which you have raised in the Clauchrie inquiry.
Maybe SPR missed it. I don't know. Yes. But this is my view. As in my role as commercial director, I cannot see how there is any association with an increased cost. I can't see how it's necessary for a turbine of exactly the same size and shape, same rotor size, same tip height, in the same location, but the size of the generator contained within the turbine means that the price payable to Prestwick is doubled. Can't see it.
Yes, but in advancing that position, you're making an assumption about what the proposed charging structure would be.
Well, it's set out in the transcript of Clauchrie. It's Ms. Kilpatrick answers a direct question in relation to a per megawatt payment per year to be going forward. So that's my answer to that, is that is not reasonable, rational, or justifiable for the reasons I've set out. And I think it's it's in evidence. It was confirmed at Clauchrie. I can't tell you whether it's 38,000, 48,000, 58,000, but it is pounds per megawatt per annum. And even if it's £10 per megawatt per annum, it's still unjustifiable with relation to the proposed development.
But you acknowledged earlier, Mr. Thompson, that perhaps SPR missed the point which is of concern to you.
Yeah, maybe. I don't know what they were thinking, but it is of concern to me, and I don't see how noting the planning circular in relation to the tests on conditions, how that could be reasonable and justifiable. I'm not a planner, and I'm not a lawyer, So I'm not going to comment on the lawfulness of a condition framed in that regard, but in my view is that it's not reasonable.
Yes, but fundamentally, Mr. Thompson, it comes to this: you don't know, do you, whether there is a mechanism within the new proposed agreement which would address your concern? You just don't know that, do you?
But I don't think that. I don't think that it can ever address my concern, because my concern is that a pounds per megawatt payment structure is fundamentally flawed. Fundamentally, it can't be changed. If it's payable in pounds per megawatt and a turbine of the same size and shape has the same planning impact, in terms of the operational and technical impact on Glasgow Presswick, there is no reason, there's no justification for the pricing structure being higher for a turbine with a higher generating capacity. It just makes it's illogical.
Mr. Thompson, that's diverging away from the question. The fact is that you just don't know what the new agreement provides to address your concern, do you?
No, but Miss Kilpatrick is indicated in her evidence at Clauchrie that it's a pounds per megawatt per annum. So, there's no evidence before this inquiry that it's contrary to that. We've put into evidence the transcript from Clauchrie where Miss Kilpatrick exceeds to that point, that it is an annual OPEX payment quantified as a pounds per megawatt charge. And that as far as I'm aware, and I'm happy to be corrected, there is no evidence from the airport to contradict that.
All right. Paragraph 2.6. Again, when you're covering the point in the first sentence that the calculation on a per megawatt basis is not a rational way of calculating the cost of any impact from a wind farm. Is that not a method of calculation which is accepted by the renewables sector and the airports and the ANSPs sector as being a way of calculating the charge?
But we're here to discuss an impact of a proposed development to a radar. That might have been the position taken by other aviation stakeholders when assessing the contribution that individual club members might make to the capital contribution for a radar, but that is not a rational way of calculating the mitigation costs associated with mitigation of the proposed development on the operational term scanter.
But you accept that a megawatt approach was adopted by renewables companies and airports and ANSPs when calculating the amount of the mitigation payment which is made by the developer?
I can't talk to what other ANSPs or airport operators have done. All I can say is my evidence is that is not a rational way of calculating, because it's not relatable to the proposed development.
Now, Mr. Thompson, you said in your evidence in chief that you had experience of negotiating these agreements. You would know from that experience the basis on which the calculation was made as to the payment.
There have been club scenarios in the past where counterparties have agreed between themselves, not involving the aviation stakeholder, that the contributions between the parties will be divvied up on a per megawatt basis. But that was an agreement between third parties, not an agreement between a developer and an aviation stakeholder.
So if we hear evidence that the airport has, its understanding is that is a method which is commonly employed when calculating mitigation payments between a renewables company and an airport and ANSP, you're saying that's not the case?
I don't think it really matters whether that has previously been employed. We're here to consider the facts before us now. The fact that people in the past might have paid for a radar on a pound per megawatt basis is of no relevance in assessing the mitigation costs associated with the proposed development. When the radar was procured for Glasgow Presswick, it might have been paid for on a pounds per megawatt basis. That might be the case, and perhaps that's the evidence that will be led. But that doesn't mean that it is a rational way of approaching the pricing structure now. For the proposed development, there is no reason to quantify the mitigation costs of this wind farm in pounds per megawatt. Cannot be justified, and it can't be justified, in my opinion, just by saying, "Oh, well, that's what the industry's always done, so they'll continue doing it like that." That's not rational. Just because something is done before, it doesn't mean that it has to be done that way forevermore.
But your view about the cost of mitigation here is based upon the fact that, as you see it, as the applicant sees it, all that has to happen here is that Terma has to be optimised to remove the adverse effect of your proposal, and that's it. There's no ongoing effect for the airport.
That was the evidence of Mr. Parkinson yesterday. Once the optimization and the modelling and flight trial have been conducted, then the radar has been optimized, and there is nothing further required beyond the general course of business for Glasgow Presswork.
And is that the basis why you say that an ongoing annual megawatt charge is not appropriate?
It doesn't really matter whether in a hypothetical scenario whereby there were ongoing works required, it still wouldn't be logical to charge a turbine with a 4 megawatt generator twice as much as a turbine with a 2 megawatt generator if they have exactly the same impact. It still doesn't make sense.
Well, we've already had that conversation. I'm not about to go back over it, but would you accept that if there was an ongoing impact and have that per megawatt charge would be a method for dealing with the cost of mitigation?
I disagree, I'm afraid.
All right. Paragraph 2.7. You say at the end of that paragraph that the airport has made a very significant commercial profit through leveraging its position as a statutory consultee. Now, in making that comment about profit, are you leaving out of account the fact that the payments which have been gathered, which you refer to in 2.8, have actually been 6 million of that, according to your analysis, or 6.2 million, has been spent on capital expenditure for the provision of mitigation?
Yes, that's our position.
Yes. And so far as the remaining 2 million is concerned, you assume that that has been taken into profit.
Well, I mean, if the costs of mitigation are 6 million and you've received 8.2 million, then yes, the inference is that 2 million of that is profit.
Now, in paragraph 2.8, you say that you oversaw the contribution agreement entered into by an affiliate. What do you mean by affiliate?
Well, it's a related company of the applicant.
So is that another member of the group?
Well, yes, it's related, yeah.
And that's a separate commercial entity with its own cost base?
Correct.
And you would know from that agreement that at that time the payment contribution was a one-off payment for the lifetime of that development. Is that correct?
I've obviously, need to be mindful of confidentiality obligations in that contract. So, I mean, but I'm aware that there are contribution agreements that are priced in pounds per megawatt. I think I've said that previously.
Yes, but my question was actually, and it's just a principle, I'm not going to start to go into the terms of that agreement, but the principle was that that was a one-off payment for that development, and the airport would not be able to go back to ask for any further contributions.
Well, yeah, I think you are, asking to get into the terms of that agreement. So it was for the procurement of a radar.
But without getting into the terms of that agreement, does the airport have any opportunity now to go back to your affiliate company to ask for any further contributions towards the cost of mitigation?
Yeah. Again, you're asking specifics about the a contract that is not in evidence, not in front of me now, and I don't think I'm in a position to answer that question for you. for the reasons of
You have said, let me put it this way, you have said that the £2 million has been taken into profit, and what I'm going to say to you is that that money, the profit as you see it, is actually reserved to meet the cost of future mitigation, which may be required for the developments.
Yeah, I mean, if that's the view of Prestwick, I mean, the technical evidence we have is that there are no future mitigation requirements, as set out by Mr. Parkinson. You know, the thermoscanter is now operational for an extensive period of time, and there are no ancillary works that need to be done in order to accommodate those wind farms that have contributed to the procurement of the radar.
Yes, but of course, that answer is given on the basis, your basis, that there is no further mitigation required. If the airport's position is that further mitigation is required, is it not reasonable that the airport sees that 2 million, as you have put it, as being money which is available to meet any further mitigation which is required?
I mean, on the basis that 2 million is, half again, basically, when not far off half again, the cost of the radar, that is, a very substantial sort of mitigation pot, especially, given that there is no technical evidence that I'm aware of before the inquiry that says that, further mitigation is necessary in respect of that radar.
Well, it's known, for example, Mr. Thompson, is it not, that there will come a point in the lifetime of the current thermoradar where it will have to be replaced.
I think this is...
And it's also known that any technology which is employed by the airport at that stage to provide mitigation for the wind farms will have to be wind farm tolerant.
I think this is the point we discussed earlier, but that'll be part of the airport's operating environment at the time, and wind farms will be the baseline, not the proposed development. You see, it'll be a wind farm environment.
So it just comes to this, that your position is that there is no ongoing impact, and therefore, in your view of the world, or the airport's operations at least, the airport doesn't need to reserve money to deal with future mitigation, and the airport is entitled to treat its profit.
If the airport is planning on using wind farms to save up to procure new radars in future, so it doesn't have to cover its own operating costs, then yeah, I would take umbrage with that.
But you don't know how the airport's treated the money, do you?
No, I'm not the FD of the airport. I don't know how the airport's treated the money, but it seems to me on the face of it that, an accounting entry for 8.2 million quid against the capital cost of 6 million quid for procurement of the asset to which the capital contributions were made results in 2 million quid of profit.
Yes, well, we'll hear from Ms. Kilpatrick on that point. Now, in terms of the regulatory regime within which the airport operates, I take it you accept that the airport has no option under the regulatory regime in which it conducts its operations. It's got no option other than to provide mitigation for developments which have an adverse impact on the airspace.
I'm not a planning expert, so I'm going to defer to Mr. Bell in respect of part of this question, but my understanding is that the statutory process is that an objection is raised if there is an operational impact to, or if there is an impact to the consortee, and that the process, if that objection can't be dropped, results in an inquiry being convened in order to discuss the objection.
So, sorry, Mr. Thompson, I'll reframe that to make it more specific. I was talking about the regulatory regime in which the airport conducts its business, and what I was really referring to, and I'll be more specific about it, is do you accept that when it comes to the regulatory regime which governs the use of the airspace, that the airport is obliged to provide mitigation for developments?
I think this is probably a technical question that should have been addressed to Mr. Parkinson yesterday. I'm not a technical expert. I'm not able to speak to the regulatory regime applicable to airports. I am able to speak to the planning regime to the extent that it's within my knowledge base, but I think that's a technical aviation question.
Well, Mr. Thompson, I had understood that you had entered into and overseen the entering into of mitigation agreements with airports and their navigation services provider. In that context, are you aware of the CAA publication on the policy and guidelines on wind turbines, which is CAP 764, which, sir, is CD 13.2?
I'm not familiar with it on a day-to-day basis.
Well, what does that mean on a day-to-day basis?
Well, you know, I'm not an airport operator, and I'm not an aviation technical expert, so
well, if we have a look at that document,
okay.
and we have a look at page 14.
Hold on. Sorry, please can you provide the document reference again?
Yes, it's CD 13.2.
.2 CAA policy and guidelines on CAP 764. Yeah.
Yes. And if we look at page 14, and if you look at paragraph 1.4, it says there that the CAA policy on wind energy is that wind turbine developments and aviation need to coexist in order for the UK to achieve its binding European target to achieve a 15% renewable energy commitment by 2020 and enhance energy security while meeting national and international transport policies. And it says there that, however, safety in the air is paramount, will not be compromised.
Mm-hmm. I see that.
That the airspace has to remain safe for use, notwithstanding the presence of wind turbines. Are you prepared to accept that's what that paragraph is driving at?
Of course, it says safety in the air is paramount and will not be compromised.
Yes, indeed. Indeed, you accept that in your recognition.
Yeah.
But do you see it in paragraph 1.3, just above 1.4, that the CAA's policy is that at all times, responsibility for the provision of safe services lies with the ATS, which is Air Traffic Services Provider, or Air Navigation Services, even Air Navigation Service Provider.
I see that, yeah.
You accept, do you, following that if the airspace is to be kept safe, as directed in paragraph 1.4, that the person who is to make sure it is safe is the Air Navigation Services Provider?
Yeah, I think that's true. I think the difference comes in that, you know, your position is that the proposed development is unsafe without an operating cost or an operating payment of, you know, however many pounds per megawatt per annum, and our position is that a safe environment is already provided by the wind farm tolerant radar that has already been installed. I don't think we're disputing, you know, these two paragraphs.
All right, so you accept then that the airport will have to ensure the airspace is safe after your proposal is built?
Yeah, it was the responsibility of provision of safe services lies with the ATS provider or the ANSP.
So do you think it's acceptable then that the airport should have to bear the costs and risks associated with your development for its operational life?
But I don't think well, there's 2 points there. I don't think we're saying that we do expect them to. We've said that we've set out the mitigation that we believe is technically required, and we've said that we're, you know, more than happy to pay for it. And then the technical evidence is that, you know, there is no further work required during the lifetime of the development other than general airport business that's not related or specific to the proposed development. That's our position.
So does it come to this then, that you recognise that the airport shouldn't be saddled with the cost and risk of providing mitigation for your proposal, It's just that your position is that that cost and risk stops at the point where the radar has been mitigated.
Well, the evidence is that there is no technical risk, or the technical risk that remains is de minimis outside of, well, yeah, there isn't any operational or technical risk. It's just operational business. We set out the mitigation actions that are required. We've provided an undertaking to pay for those. We've priced them at 60 grand. We haven't heard any evidence from Glasgow Prestwick to the contrary of that. We just seem to have, a refusal to disclose the costs associated with mitigating the specific wind farm. And we take from the transcript of commercial director of Glasgow Prestwick at Clauchrie the mitigation costs that they consider to be, and I guess this is just a one-size-fits-all approach to wind farms, is pounds per megawatt per annum, which I disagree with.
Well, the fact remains that in offering your undertaking to pay, and that's obviously it's a matter of dispute between the applicant and the airport as to whether that goes far enough, but at least by you offering that undertaking, you recognise that the airport should not be left with the cost and risk of optimising the radar in the first stages to mitigate the effect of your proposed development.
I think the risk point was addressed yesterday by Mr. Parkinson, in that there are no, when we turn to the risk table, the risks throughout the process are either already addressed as part of this process and the mitigation works that we've undertaken to pay, or not specific and applicable to the proposed development because they comprise general operating risks for commercial airport, such as Glasgow Prestwick. And therefore not relatable to the proposed development. They're just related to your business as an airport.
But the fact remains that you are prepared to pay the cost which you see as being related to your development.
We've taken technical advice on the extent of the mitigation works that are necessary to accommodate our proposed development within the existing operational wind farm tolerant thermoscanter that was procured for Glasgow Prestwick. And that is the crux of it. The airport already has a wind farm proof radar. We've accepted that we are liable to cover the implementation costs of incorporating our wind farm into that wind farm tolerant radar, and those are set out by Aegis in their technical report. The advice and the evidence of Mr. Parkinson is that there are no further risks, so there are no further costs. So there is no requirement for a pounds per megawatt operating cost on an annualized basis, notwithstanding that pounds per megawatt doesn't have any rational association with the wind farm being mitigated.
But my question is this, Mr. Thompson, that by offering that undertaking, you recognise that the cost of providing mitigation for your development should, and I appreciate there's a question about how far that should go, but you recognise that the cost of at least providing mitigation in the initial stage should not fall upon the airport.
We're not expecting the airport to cover these costs. We've said that we will pay the cost of the modelling, the optimization, and the flight trial. Those are the only mitigation costs that have been considered necessary by our technical expert. We're not technical experts. We take advice on these things, but that's what the independent technical expert says. These are the costs and these are the actions. This is the scope of works necessary to accommodate the proposed development, and we've said that we will do those because and we haven't had any evidence. The £60,000 is our assessment of what those costs are. We provided those to Prestwick. We haven't had a response to to dispute those costs. We haven't had any engagement. We've had a request to sign a non-disclosure agreement, which would preclude us from having having a dialogue in the correct public forum that is a panning inquiry. So I'm not aware that there is any evidence before this inquiry to contradict our costs. The only evidence before this inquiry in relation to the reasonable costs of mitigating the proposed development are the ones that we put forward. There are no other costs before this inquiry, so I don't know, what other costs there are to consider.
Right. On the question of non-disclosure, which is covered in section 3 of your recognition, would you accept that when two commercial organisations have a discussion about the terms of an agreement, they will usually have some sort of confidentiality put in place to allow those discussions to take place?
But the airport isn't a commercial organisation in the context of a statutory consultation process. It's not acting as a commercial organisation, it's acting as a statutory consultee. The fact that it undertakes commercial business is not related to its function in the planning process as a statutory consultee. We haven't asked to enter into a commercial contract with them.
Well,
the Scottish government asked for a consultation response in relation to a planning application.
well, the fact is that when we discussed the earlier agreement, which was put in place with the airport, and that's the one between your affiliate company and the airport, that was protected by an obligation of confidentiality, was it not?
Well, we're on thin ice again, discussing other agreements.
Well, I'm not asking to discuss the terms of the agreement. I'm just asking you, well, you accepted that that was covered by an obligation of confidentiality and you didn't want to discuss it. So you have previously recognised as an organisation, have you not, that it is appropriate to have confidentiality applied to agreements entered into with the airport?
We have entered into wind farm mitigation agreements with other aviation stakeholders, and those contracts for mitigation services include confidentiality obligations. What we haven't done before is accede to a non-disclosure agreement just to talk about a mitigation services agreement, because what that would do is prohibit us from joining this process and actually discussing the outstanding obligation in a public forum, because as soon as the non-disclosure agreement is signed, we're completely banned from having this conversation.
Well, we'll come on to that point, but the other benefit, of course, of a non-disclosure agreement is that it protects all parties. This wouldn't have been a one-way non-disclosure agreement, would it? It would also have protected the applicant from the airport disclosing any information it had learned in the course of the discussions.
But I mean, it's not. There's nothing. We would be the receiving party, in respect of this commercial information, supposed commercial information. Our position is that we're talking about the proposed development. We're not talking about any other developments. We're not talking about, the airport's approach to other wind farms. We're talking about the specific costs necessary to accommodate and mitigate the proposed development.
But even if any information which the airport had obtained in connection with your development in the context of those discussions would have been protected by the NDA, would it not?
I'm not really sure I understand that point. Say that again.
Well, let me reframe it. The NDA would have provided protection for the applicant here against the airport disclosing anything the airport had learned about the applicant's intended operation at Sanker, would it not?
I mean, it'd be a bilateral confidentiality agreement, no doubt, but I'm not, we have no concerns about, it's a public process. That's we're happy to have this conversation in a public forum.
Well, in the absence of a non-disclosure agreement, the fact remains, is it not, that one party could seek to employ the information obtained in connection with discussions about a proposed agreement. They could employ those against the other party to those discussions, could they not?
We could employ them. How do you mean?
Well, you could use them against the other party.
That's, we're not, it's, the point of principle here is that this is a planning process. It's a statutory process. The particular matter that we're considering, in these proceedings is the necessary mitigation activities required to address the impact of the proposed development on the operational thermoscanter radar.
Mr. Thompson, I didn't ask you about any points of principle here. I had just asked you a straightforward question about the benefit of an NDA. And my question to you was that in the absence of an NDA, there was the risk that one party could seek to employ any information obtained in a discussion about a contract to be entered into, or an agreement to be entered into. They could employ that information against another party.
But I mean, how would we employ it against another party? It's specific to the proposed development.
Well, Mr. Thompson,
the disagreement here is in relation to the actual costs necessary to mitigate the Sanka wind farm. It's not, in relation to, an adversarial process, or, we propose some costs and we haven't had any contrary response to that other than the historic 38 grand a megawatt.
well, does the fact that remain, Mr. Thompson, that we don't have to look very far beyond this inquiry to see an example of where one party is trying to use information obtained in connection with a prospective agreement against the other party. And what I have in mind there is, if we look at paragraph 2.4, refer to information which you previously obtained, which was not protected by confidentiality. And you're now seeking to employ that against the airport, are you not?
Well, only because we consider it to be unreasonable.
Yes,
it's not justifiable. So the point is that it's not justifiable in relation to the mitigation activities that are necessary and proportionate. So are we not within our rights to object to numbers of those quantum?
Yes, well, of course, the point is that you can refer to it, can you not? Because you didn't sign an NDA before you got it.
Yeah, but if we'd sign an NDA, we wouldn't be able to refer to it at this inquiry, and then we just get forced into accepting it because there's no way out. It's that's the reason why we couldn't sign an NDA. No reasonable organisation would have been able to sign that NDA. Because you say, all right, we sign the NDA, the process would be sign the NDA, you disclose to us that actually it's not 38,000 anymore, it's 48,000 and it's a per annum cost. Where do we go? We've got nowhere to go. We can't come to the DPA, we can't come to a public inquiry because we wouldn't be able to disclose that the costs that you proposed are unreasonable or not proportionate or not related to the necessary mitigation. And our position is that this isn't this isn't a commercial negotiation. It's not about two counterparties to a commercial deal negotiating a settlement and negotiating commercial terms. It's about the cost and cost recovery, not profit, cost recovery of an airport accommodating a wind farm as part of a statutory consenting process. That's the scenario.
In paragraph 3.1, you say that at the end, the applicant has also advised GPA that it would be willing to consider a response received on a without prejudice basis, but it has still not received a response.
Correct.
On the question of this without prejudice basis, do you mean that you would not have been able? Well, what do you mean by without prejudice?
Well, we put forward the three mitigation items and the cost that we'd assess to be associated with each of those. We put them to GPA on a without prejudice basis, and we've had no response.
What my question was, what do you mean without prejudice?
I think that's a fairly well-known term.
Yes, what do you think it means?
Well, without prejudice to any further proceedings.
Yes. And that would mean that you wouldn't be able to disclose what you had been told in that response, would it not?
What, to a court? This planning inquiry?
Yes.
Well, we haven't had a response, so.
No, well, that's not my question. My question was that you're saying that you were happy to receive a without prejudice response, and I'm saying to you, well, if you had got a without prejudice response, you couldn't have referred to the terms of that response in this inquiry, could you?
No, but we were trying to, we were trying to remove an objection and avoid this process. We just didn't. We haven't had a response.
Yes, but you accept that you wouldn't have been able to refer to the response in this inquiry.
Well, I mean, it's a hypothetical scenario because we haven't had one. So
I'm asking you whether, if you had received a without prejudice response, you would not have been able to refer to it in this inquiry.
I would probably have referred to our legal advisors as to its admissibility, but no, I suspect not.
Now, on this question of you've advised the applicant that you'd be willing to consider a response on a without prejudice basis, when was that offer made to the airport?
I think it was the 30th of July.
Do you have a document reference number for that?
Bear with me 2 seconds. Not immediately to hand, but I can. We can come back to it if you want to continue.
All right.
Wait. Okay.
Now, in terms of this issue about the NDA, do you accept that over the course of the summer there were negotiations about the terms of an NDA?
Yes.
And if we have a look at the negotiations there, if I can ask you to look at document CD 1987, please.
Sorry, CD 19.
Stop, 87.
Sorry, the reference, I think. I think the reference I was looking for is APP 002-009.
Just give me a moment.
Sorry, and the document reference you were looking for again was CD 1987.
Sorry, if you can just give me a moment while I get that reference document in front of me. Just give me a minute, please.
Okay.
Mr. Thompson, thank you. I've now got that document in front of me.
Yep.
I'll be referring to a letter from your solicitors to
Denton's, yeah.
on the 30th of July.
That's it, yeah.
Can you show me or directly to where you specifically say you'll consider a without prejudice response?
Just let me scroll through it. Oh, it's not searchable. No, I can't find it. Trying to search. And it must have been a covering email. I do apologise.
Yeah, so there's no evidence before the inquiry then about the fact that you offered to consider a without prejudice response.
No, there's no evidence before the inquiry.
So are you withdrawing that suggestion then that there was?
Well, it's not in evidence, so I can't. Yeah, I mean, I can say that it was made, but I can't point to it in evidence.
So we just have your word for it.
Yeah.
All right. If we look at the CD reference number, which I was referring to, which is CD 1987, and I think you had acknowledged that there have been discussions between your solicitors and the solicitors for the airport over the summer about the terms of a non-disclosure agreement.
Yep.
Yeah. And if we look at page 3 of that document.
So I just it's taking a little while to load up.
Yeah.
Here we go. Email from A. Cornelius to Keith Campbell, 26th of August.
Yeah, correct. And this, you would accept, no doubt, that this email arrived or is sent at a point when there's ongoing discussion between the parties about the terms of the proposed NDA.
Yep.
And by this point, the inquiry statement has been lodged, and Ms. Cornelius says in the paragraph under the heading NDA, we note from the inquiry statement that your client is not prepared to consider the NDA, which is regrettable, as it is surely in the interest of both parties to have a conversation about the terms being proposed before the inquiry commences. Those terms are in your approach and are materially different to the earlier iterations of the wind farm mitigation agreement which your client would have seen to date. Our client remains willing to have such conversation with your client. If there are particular terms of the NDA which cause difficulty, then the airport should be grateful if you'd at least let us know what they are, in order that we may consider whether it's possible to amend the NDA, all with a view to allowing a conversation to take place between the parties. So do you accept from that statement that what the airport was trying to do at this point was acknowledge your concerns, but nonetheless find a way through to allow the parties to have a conversation to see whether the matter was capable of being resolved?
Of course, that was the the dialogue between us was to establish whether or not there was a way in which terms could be disclosed, and unfortunately we just weren't able to agree.
Well, if you look at page 2 of the document reference 1987, which I have before you, we see there's a response from Keith Campbell to Amy Cornelius, and that's responding to the email of the 23rd of August, which we just looked at.
Mm-hmm.
And we see in paragraph 2 there that Mr. Campbell says, in particular, my client would be happy to discuss the terms of your client's wind farm mitigation agreement in advance of the inquiry session. However, the issue of the WMA and disclosure of its terms is entirely in your client's power, and to date your client insists that disclosure of the terms of the WMA can take place only if my client first enters into an NDA. The NDA precludes any discussion of the terms of the WMA at the forthcoming inquiry session. And then he goes on to say that the effect of the NDA is to take the discussion of necessary mitigation and cost.
This is the point I've been making in my evidence.
Yeah. And then Mr. Campbell continues by saying, more particularly, your client, through their legal agents, has refused to exclude from the scope of confidential information as defined in the draft NDA any previous correspondence relating to the terms of your client's WMAs. This would prevent my client from disclosing to the inquiry email correspondence in which the financial terms of previous WMAs were disclosed to my client. In the context of the current inquiry process, what is proposed is that in order to see the terms of the proposed WMA, which your client otherwise is refusing to disclose to my client or the inquiry, my client must first sign an NDA which prevents reference to these terms of disclosure of any other information as to the terms of your client's previous WMAs. This information may assist the reporter. And then it goes on, more pertinently, my client is willing to consider entering into the NDA in order that the terms of the refreshed WMA can be disclosed and discussed between the parties, but my client is not willing to accept that correspondence or information in relation to wind farm mitigation and costs that was obtained prior to entering into the NDA be restricted and classed as confidential information. If your client is willing to amend the NDA on this basis, then my client may be open to entering into such an NDA. Now, I appreciate that Mr. Campbell said that you may be open to entering into such.
Yeah, maybe, maybe, or willing to consider.
Yes. And if we then look at the first page, page 1 of that document, what we have here is Cornelius's response to Mr. Campbell of the 26th of August 2021. And do you acknowledge that in the second paragraph, the very first sentence says, in terms of the NDA, my client is content to amend the document as requested to allow the NDA to be signed up to.
Yep.
And that's been copied to James Thornton at Pinsent's, because I think we can just agree that Pinsent Masons were dealing with the drafting of the NDA. So do you accept that you, in that correspondence, or your agents at least, expressed a concern about the terms of the NDA, and the airport said, all right, we will address those concerns and we will frame an NDA which takes out of account or the information which is of concern to you, so that we can have a discussion. Is that a fair summary?
I mean, it's that's it's there in writing, but obviously we said we were willing to consider it, and upon reflection, we considered that signing up to any NDA was going to be prejudicial to having this conversation in this forum. The scenario that we played out was we accede to an NDA that doesn't preclude us from disclosing the previous terms that we've disclosed to the inquiry. But as a result of entering into the NDA, we are provided with the updated terms, which are even more prejudicial in our view. So then we come into this inquiry process knowing what the revised terms are, knowing that they're worse than the original terms. We're not allowed to talk about them. And the position, as far as we're concerned, is completely unchanged. We're not really sure why the airport is unable to disclose the terms of the necessary mitigation pertaining to the proposed development to this inquiry. we just don't see why the airport's unable to disclose the costs, the relatable costs to this wind farm. That's what needs to happen, and we don't see that an NDA is required to do that. We didn't want to take the risk that entering into an NDA, would prejudice this process.
But the fact is that if you were of that view that you thought it might be prejudicial, why did you go through December
Okay.
to September?
Right.
Negotiating a non-disclosure agreement with the airport.
Yeah, I take the point. We said we'd think about it, and then the airport said, okay, we'll update the NDA, and then we said, all right, I tell you what, we've slept on it overnight, and we're still not really comfortable with doing this. That's the situation here. Nothing, our position has always been that the cost should be disclosed in an open forum. We're very uncomfortable with NDAs in general, particularly in relation to statutory processes, and that nervousness is valid.
But if you had signed the NDA, well, the thing is, I suppose you accept that we don't have the terms of the NDA in front of the inquiry to the point when it was last negotiated. But the fact is that would you not have been better to suggest revised wording to allow a discussion to take place, because at least then you would have been to make an informed decision as to whether you were prepared to accept the terms or not.
The point is that any terms that are priced in pounds per megawatt per annum are going to be unacceptable. That was the evidence in Clauchrie, which I believe was prior to this exchange being concluded, and this scenario would have been that we entered into the NDA. You provide us with updated terms, priced on a pound per megawatt per annum basis. We say that's not reasonable, rational, or fair, and then we come into this inquiry process to have this discussion, knowing the updated terms, knowing that they're more unreasonable than the last set of terms, and unable to discuss them. Our positions in this inquiry process is no better than we are just now.
Yes, but you also indicated in your recognition that you were prepared to consider a without prejudice response, which couldn't have been disclosed either. So,
but that doesn't bind us in terms of non-disclosure. Other than to the extent that without prejudice offers are inadmissible as evidence. But it wouldn't be. I'm not a lawyer, so I'm going to just note that I'm not in a position to advise on whether or not what the ramifications of receiving a without prejudice offer are, but it wouldn't be a contract between the parties.
Yes, but I think you agreed that as you understood it, you wouldn't be able to refer to the contents of a without prejudice response in this inquiry.
No.
Yeah, so what I'm struggling to understand, Mr. Thompson, perhaps you can help me with it, is why, if you were prepared to consider a without prejudice response, which you couldn't refer to in this inquiry, why were you not prepared to sign an NDA? Because it would have been the same effect.
Would it? An NDA is a full and comprehensive agreement. Receipt of an without prejudice offer is just receipt of a without prejudice offer.
Which you couldn't refer to.
Which we couldn't refer to, yeah. But it's not the same as a non-disclosure agreement.
No, I think you said that
they might have some similar effects, but they're not the same.
Okay. I think you said that you generally dislike non-disclosure agreements. Do you not?
Yeah, in planning processes.
Now, in connection with the process which is underway before the inquiry here, have you sought to obtain NDAs in order to enable discussions with other objectors?
I don't think that's of relevance to, the position here.
Well, I'm just asking you a question. Have you sought to obtain NDAs in connection with discussions with other objectors?
I genuinely couldn't tell you.
Okay. Well, if I can ask you then to have a look at a precognition which has been lodged in this inquiry from Hugh Liggett.
Okay. Can you give me the document reference?
I'm sorry, I don't know that I have that because I think they're kept in separately.
Precognition. I think it's yeah, I have it. Okay.
Now, I appreciate that Mr. Liggett hasn't yet given evidence to the inquiry, but if we look at paragraph 11 of that precognition, he says the developer, if you have it.
Yeah, I have it here, yeah.
Yeah, the developer has twice tried to buy my silence in opposition to this wind farm. He made an offer verbally for £2,000 in favour of assuming rights over who stayed in my house, help for the developer and a non-disclosure agreement, and he refers to a document in the footnote. And then a £3,000 annual offer, an NDA, and still retaining succession rights over my property. Now,
I mean, sorry, go on.
yeah, and then that, the footnote, which are referred to as shown below at 6, CWP Draft Minute of Agreement dash K. Kelshaw, 17 September 2019 NDA. And K. Kelshaw, as I understand it, is an in-house solicitor employed by Community Wind Power. Is that correct?
That's correct, yeah.
Yeah. So, as I said, I appreciate that Mr. Liggett has not yet given given evidence to the inquiry, but if his evidence is accepted on that point, is that not hypocrisy on the part of CWP that it's prepared to seek NDA agreements from parties who are part of this process, but equally it's not prepared to enter into them?
I don't think so. I mean, obviously this is Mr. Liggett's evidence. It wasn't me that made an offer of NDA. If an offer was made, it's entirely different circumstances. I don't think.
What's different about it, Mr. Thompson? It's part of this process which you think should be open and transparent.
Well, I mean, it's a similar argument to us saying that we've entered into wind farm mitigation agreements with other parties, so why haven't we entered into one with you? The point is that, the requirement is excessive.
Well, that's going off the point, Mr. Thompson. You have expressed a fundamental objection to the idea that the effect of an NDA in the context of a public process like this is it creates, to use your phrase, a closed system. That's the phrase you have used in paragraph 3.2 of your proposition. It's a closed system. And what I'm putting to you is that if that is so objectionable to CWP, why did it also seek to employ such a closed system so far as Mr. Liggett is concerned?
Well, I guess that Mr. Liggett took the same view as us and didn't accede to the NDA, probably for the same reasons that we're doing, because he wanted to have the conversation in a public forum.
Mr. Thompson, I'm not asking you about Mr. Liggett's reaction. I'm asking you about the decisions which you have made here. CWP decided to ask Mr. Liggett for a non-disclosure agreement in his evidence on 2 occasions. And what I'm asking you is why CWP did that if it has a fundamental objection to creating closed systems within the context of a public inquiry.
Well, because it's the situation here is that the requirement to enter into an NDA is being requested or demanded by a statutory consultee. Mr. Liggett's entitled to refuse to enter into an NDA. That's his right.
Again, Mr.
What we're faced with here is a statutory consultee demanding that prior to disclosure of the purported necessary mitigation costs, we must enter into an NDA to essentially stymie a statutory process.
Mr. Thompson, you're attempting to divert away from the point of my question, and that is that if the applicant has such a fundamental objection to NDAs in the context of a public local inquiry, why did it ask for an NDA from Mr. Liggett?
Well, I mean, I think actually pertinent point here is that we disclose the cost to him because he's specified them in his precognition, whereas we were being required to sign into an NDA in order to receive costs that we might thereafter find prejudicial and find ourselves in a position where we're unable to voice them in public, voice those concerns in public.
No, it's a fundamental point, Mr. Thompson, no, that you were trying to create the closed system which you find so objectionable.
But it's in relation to you're a statutory consultee. Glasgow Prestwick is a statutory consultee in a statutory process. Mr. Liggett is an individual in the same process, admittedly, but he's an individual. He doesn't have any statutory position. Glasgow Prestwick has a statutory position in this process. It's not right. It's fundamentally different. You have a statutory obligation to engage with this process, and in order for us to understand what costs you consider to be necessary and relevant and associated directly with the proposed development, you required that we accede to an NDA, which then completely cuts across the rest of that statutory process. I disagree. I think it's an entirely separate, different scenario. The fact that we've just mentioned NDA is the only similarity.
Yeah, you said there that the airport's statutorily obliged to engage in the process.
Yeah. You're a statutory consultee, so yeah, that.
Yes, but was the airport not trying very hard over the summer to find an acceptable form of NDA which would allow that process to take place?
Well, I mean, they could have just said, okay, well, we're allowed to disclose all the terms of the public inquiry. I mean, the airport could just disclose the necessary costs of mitigation to this inquiry. I mean, there is a secrecy to these costs, and we set out what we think they are, and all we want to know is what Prestwick consider them to be. We don't see that we need an NDA to receive that information.
All right. It's also known in the context of this inquiry that NATS previously lodged an objection, and that NATS have now withdrawn that objection. So could I ask you please to look at CD lessons 6.11?
CD. Sorry, just bear with me one moment. CD 6.11.
Yes.
I'm struggling to find that here.
Mr. Thompson, if you have the core documents list,
yeah,
they have hyperlinks into the DPA website, so you can link. You can, if you're on the internet. Well, yeah, you must be on the internet. So.
Yeah, yeah. So DPA website. And what is the document?
The document is an email from NATS Safeguarding to Stephen McFadden at the Energy Consent Unit dated 14th of August 2020.
Okay. (14th of August 2020).
Yes.
Yeah.
Do you have that?
Yeah, it's just coming up now.
Yeah, and that
Okay.
is the email saying, "Dear Stephen,
Yep.
NATS still expect the development as proposed to have an unacceptable impact on our operation. However, we are working with the developer to deliver mitigation in advance of the development's construction, and our position remains as stated in our email of the 12th of February, copy attached."
Yep.
Now, the issue here is, of course, you would agree that NATS, like the airport, is being consulted because it's a statutory consultee.
Yeah.
Yep. And if we look at the letter of 12th February 2020, which is just behind that email.
Yep.
The third paragraph says, "An agreement has been entered into between NERL and Sanctuary 2 Community Wind Company Limited dated 31st of January 2020 for the agreement of suitable planning conditions and the implementation of an identified and defined mitigation solution in relation to the development that will be implemented under the agreement. Such mitigation solution will require works to be carried out to NERL's infrastructure and comprises a radar coverage suppression zone, along with the use of infill radar coverage from another of NERL's primary radars." And it goes on to say that NERL is therefore prepared to withdraw its objection, subject to its proposal of a condition.
Yeah.
So we can see from that that the applicant here has entered into a mitigation agreement with NERL or NATS.
Yeah, I mean it's a different scenario though, isn't it? The objection raised by NATS was in relation to Lowther Hill, which is not a wind farm tolerant radar. So the proposal from NATS was for a blanking and infill mitigation strategy. That was assessed by our technical experts. It was determined to be necessary and relevant. Costs were proposed by NATS. Those were assessed to be proportionate, relating specifically to the necessary mitigation works. So it was accepted.
Yes, and is that mitigation for the lifetime of the development?
Yeah, I mean, it's mitigation for the development for the duration of the planning consent.
And is that, before we go any further, is that agreement protected by confidentiality?
It is.
Yes, so we have an example there of the applicant being prepared to enter into a confidential arrangement with a statutory consultee. Is that not correct?
Yeah, but I mean, it's for a well, I mean, it says it there in that you know, in that letter of 12th February 2020. It's for blanking and infill. So those are necessary mitigation actions that are associated with our impact on the Lowther Hill radar. It's different. Glasgow Prestwick has a wind farm tolerant radar. NATS doesn't. So NATS needs to blank and infill that radar. There are different costs associated with that. It's a different scenario. It's not comparable. The only similarity is that NATS is an aviation consultee. That's the only similarity.
Well, is the issue here that you're quite happy to have discussions with NATS and enter into a confidential agreement with NATS as a statutory consultee, but you're not prepared to do the same with the airport. Is that not the point?
NATS didn't require that we sign up to a non-disclosure agreement before telling us what the costs would be.
But the
Yeah,
fact
that's the fundamental, that the agreement's confidential because we entered into an agreement, but prior to getting to the stage where an agreement is drafted and negotiated, the costs that are going to be included are set out for the parties. If Nat said, oh, we'll tell you the cost, but only if you sign a non-disclosure agreement first, we'd have said no.
But you are still prepared to enter into confidential arrangements with statutory consultees, are you not?
Of course, but we're just not prepared to accept confidentiality undertakings in respect to disclosure of costs before we get there. That's the point. You know, if Glasgow Prestwick's content to disclose the necessary costs to this inquiry, we can consider them. But the point is that Prestwick's not content to disclose the costs.
Now, in paragraph 3.5, picking up that theme, paragraph 3.5 of your recognition.
Yep.
You say that in the second line, GPA has disclosed the costs it was seeking under the previous WMA, and the applicant is unable to see a legitimate reason why it would not be prepared to do the same now.
That's right.
Now, if we look at a document reference APP 22,
Sorry, Mr. Brown, could you repeat that reference, please?
yes, it's APP 2.
Yep.
.22.
Thank you.
Yeah, I have it here.
And if we look at page 3 of that document,
we see the cost 38,000 and then 28,500.
well, just if you just let me take it more slowly, just so that we understand what this is first. Here we see an email from Scott McKenzie, who at that time was commercial director at Community Wind Power.
Yep.
Yeah. And that is to James Thornton at Pinsent Masons, who is the solicitor who was acting for the airport in connection with the matter at the time. And what has happened here is, as you have indicated, if we turn to page 4, we see that it's actually been put to Mr. Thornton, and it's looking at the third line down. It's been put to him, Mr. Thornton, as follows: we believe from previous engagement, these commercial discussions are based around a 38,000 per megawatt installed contribution to radar investigation. So that's put to Mr. Thornton as a proposition by Mr. McKenzie, isn't it? You agree with that? And if we then look at page 2 of that document, this is an email from James Thornton to Scott McKenzie, and it's the third paragraph, which is of particular importance to us here for this discussion. On the level of contribution, GPA's position has moved on from the position that you have set out below. Developers are only required to pay £38,000 per megawatt in respect of those turbines which are identified in the aforementioned feasibility assessment has been visible to GPA's air traffic service and requiring mitigation. Further, for the proportion of a developer's capacity which exceeds the required contribution is reduced to 28,500 per megawatt. Now, when you refer to the previous terms which were disclosed in paragraph 2.4 of your definition, this is the email, this is the disclosure process you're referring to, is it?
Sorry, I didn't quite catch the final sentence there.
But when you refer to the previous terms in paragraph 2.4 of your recognition,
yep,
that is where this information was obtained.
Correct.
Email exchange.
Yeah.
Now, if Ms. Kilpatrick's evidence to the inquiry is that it wouldn't be usual for the airport to make that information available in that way, what would you say in response to that?
Well, I mean, Pins and Masons were the airport solicitors, and that information was disclosed by the airport solicitors to Community Wind Power. So,
okay, and you have all acknowledged that there was a previous agreement in place, or an earlier agreement at least, with your affiliate company.
Well, there was.
So there was a pre-existing relationship between the airport and the affiliate company. Now, if Ms. Kilpatrick says that the information was passed to you via solicitors on the basis of that previous relationship and in good faith, that they would trust you with it, what would you say in response to that?
Well, it's just not. This is just not what the evidence is. I mean, it's, you know, it's quite clearly in relation to Sanka 2. I mean, it starts, you know. I take you to the paragraph on the final page. Oh, sorry, the second from final page, page 4 of the PDF. The top paragraph: community wind power 350 megawatt wind farm project Sanka 2 submitted for section 36 planning. Although 20 miles away, it is in the line of sight of Prestwick radar. Prestwick Airport have objected on these grounds, but in the objection, notification indicated a willingness to enter into commercial discussion with community wind power. We believe from previous engagement that these commercial discussions are based around a 38 grand per megawatt installed contribution to radar mitigation. If you do the arithmetic, this adds up to over 13 million. Such a sum is completely unjustifiable. You can't then say that, you know, this whole email chain pertains to the, you know, affiliate contract. That's just not correct.
Mr. Thompson, I made no such suggestion. What I'd put to you was that if Ms. Kilpatrick says that you got the information in that way.
Well, we didn't. We got it from James Thornton in this email on 11th of July 2019.
Mr. Thompson, it would be helpful if I maybe just finish the question. What I said to you the last time was, if Mr. Kilpatrick says that you got the information through solicitors, having regard to the fact that you had a previous relationship, that it was passed to you in good faith, and that looking at that previous relationship, the airport trusted you with it, what would you say in response to that?
I think that's unfair. Don't think, you know, there's you making out that you know, it's an act of bad faith on our part to disclose this email to the inquiry. You know, the fundamental principle here is that Glasgow Prestwick is not happy to disclose any costs associated with mitigating the wind farm to this inquiry. That is the fundamental principle. You know, our position is that Glasgow Prestwick has a wind farm tolerant radar. We set out the costs that we consider are necessary, and Prestwick's just saying nothing about how much, you know, is necessary to mitigate the development, or the, you know, to even price the steps that we've set out. And to you know, to suggest that it's an act of bad faith on our part to disclose this email, where Glasgow Prestwick solicitors set out those costs, used to be, you know, used to be at 38,000 and 28,000 per megawatt above that. I think it's unfair to say that's an act of bad faith.
Well, what I'm putting to you is Ms. Kilpatrick's explanation as to why you previously got the information without an NDA.
So what's Ms. Kilpatrick's evidence going to be?
Well, Ms. Kilpatrick is going to say that you had a previous relationship, the information was passed to you in good faith.
Mr. Hardy.
So I hesitate to interrupt cross-examination. I very rarely do, and obviously it's a matter for you. But we've had an hour of this, and it seems to me to be irrelevant to the issues which are live to the inquiry. It's an attack on character, and I think if the airport is suggesting that somehow the evidence should be withdrawn, then could it make that request? And obviously that can be determined. If not, I wonder whether we could have a more efficient use of inquiry time.
Well, sir, the point here which I'd got to where the objection is made is that Mr. Thompson has said quite clearly in his recognition that GPA has disclosed that the cost it was seeking under the previous wind farm mitigation agreement, and the applicant is unable to see a legitimate basis why it would not be prepared to do the same now. And Ms. Kilpatrick, in response to that, is prepared to give evidence, as she's entitled to do, with the explanation as to why that was done in that way. And in fairness to Mr. Thompson, I'm giving him an opportunity to respond to the evidence Ms. Kilpatrick will give.
So, I mean, without being flippant, obviously, is to say, so what? That's not probative of any of the issues that you need to determine. This can all be reduced to this point. GPA is not prepared to disclose the costing or the mechanism for the mitigation requirement, and really what's gone on before isn't terribly helpful. So I just make the point, it seems, to having observed this, obviously it's a matter for you, but if there's a request for that to be a request for that evidence to be withdrawn or for you to determine on that, and let's have it.
I think in terms of where we are at this point, I'm content for Mr. Thompson to give a final answer to this line of questioning. Then we can move on, Mr. Brown. Then obviously,
Yes,
Mr. Hardy, you'll get the opportunity to ask Miss Kilpatrick about any matters arising also.
Yeah, yes, exactly. Well, yes, I probably won't, but yes, thank you very much for the opportunity.
Yes, I can assure you, sir, that this was actually my last question on this point.
Okay, thank you.
So, Mr. Brown, could you just ask the question again, please?
So what I was doing, Mr. Thompson, was I was putting to you Miss Kilpatrick's explanation as to why you got the information about the £38,000 per megawatt charge to you fee. And the evidence, as I understand it, she will give is that the information was passed via solicitors because you had a previous relationship, and it was passed to you in good faith, and on the basis that the airport would trust you with that information. And my question to you was, what would you say in response to that?
Well, obviously, Miss Kilpatrick hasn't given evidence yet, and I'm not aware that that statement's in her precognition. But I think my position would be that, you know, the application is a standalone application. It's not a point that's been made before that, you know, the previous relationship was governing the dialogue between the parties. The email correspondence is not couched in that way. So, you know, I think it's unfair, and I think that, you know, it's clear on the face of it that, you know, the solicitors acting for Glasgow Prestwick set out what the terms of the previous mitigation services agreement were. I think that's the long and the short of it.
Okay, well, I have your answer on that point.
Mr. Brown, before you continue, sorry to interrupt you. Just keeping one eye on the time. How much longer do you think you need for cross-examination? I'm just thinking about whether we break now for lunch or whether we finish this part.
Yeah, we'll finish this bit. If not just before lunch, maybe shortly after, sir, but not very much.
Okay.
So, lunch.
Let's continue. Thank you.
Yeah. Now, in paragraph 4.2, you see that at the end of that paragraph, so it's moving on to the last page, and it's 2 lines from the top, that you see that GP is simply not in a position to argue for anything more if it's not prepared to reveal the contents of its WMA and charging mechanism to the reporter and Scottish ministers to allow it to be the subject of debate in the public arena. Is that not focused, that statement, is that, with regard to that statement, is that not focusing on the wrong point? Is that not just an attempt to avoid a discussion about the impact in the longer term on the airspace surrounding the airport?
No, I think it's, you know, you're not, my point is that you're not prepared to reveal, Glasgow Prestwick is not prepared to reveal the contents of its wind farm mitigation agreement and charging mechanism to the reporter. That's my point. The technical evidence was, you know, in relation to the risk table and all the rest of it was addressed by Mr. Parkinson. My point here is that this is about cost, and because Prestwick is not prepared to reveal the contents of its agreement and charging mechanism, or even just the charging mechanism, you know, leaving the commercial terms, you know, aside, just the cost is refused to be, you know, disclosed. That's my point.
You're not trying to suggest that the airport's not entitled to argue in this inquiry that there will be ongoing impacts on the space?
Yeah, I mean, obviously, your cross-examination yesterday of Mr. Parkinson, went some way that your line of questioning was in that regard. No doubt we'll hear evidence from Mr. Fido and Ms. Kilpatrick. But the point I'm making here is it's purely in relation to cost. Glasgow Prestwick will not say what the costs are.
Yes, but it doesn't.
And my point is that the costs have to be reasonable, proportionate, and related to the proposed development in order to meet the tests on the planning circular. And because we don't have any of the information as to how it meets any of those, I don't see how any condition could be applied.
Now, just picking up a couple of things from your evidence in chief, Mr. Thompson. You were asked about whether there may be an option for maybe an arbitration here in this, overseen by a third party. Now, in terms of the CAP 764 document, which we looked at before, which is CD reference number 13.2, and I'd like you to look at page 58, which is paragraph 4.25. Yes, let me know when you got it. And it's page 58.
Page 8.
58, sorry.
58, sorry. Yep.
And it's paragraph 4.25.
CAA provision of advice.
Yes. Towards the middle of that paragraph, this paragraph is generally dealing with discussions between the stakeholders, and it says in the middle of that paragraph, however, if these discussions break down or an impasse is reached, the CAA can be asked to provide objective comment. You see that?
Mm-hmm.
Would that be a possible route to resolving the issues which have arisen between the airport and the applicant here?
No. That just says if these discussions break down or an impasse is reached, the CAA can be asked to provide objective comment. It doesn't say that it's an arbiter or has any role in dispute resolution. That's what this process is for.
Right. Now, on when you were asked about the table of costs and risks, the point was put to you generically. Sorry, when the table of costs and risks was put to you, your response was that it was just generic risks which didn't relate to the development. I take it you would accept that in the context of this inquiry, it's for the reporters and the Scottish ministers to determine the costs and risks which attach to the proposal before it.
Well, yes, but how is a reporter able to assess what the costs associated with the necessary mitigation steps are if it doesn't have any cost proposals from Glasgow Prestwick? How is the reporter able to assess those if Glasgow Prestwick hasn't put any costs forward?
Now, can I ask you this? I've only got a few more questions for you, Mr. Thompson. Can I ask you this? You've obviously been watching, or you've familiarised yourself with what happened in the Clauchrie inquiry, and you're aware from the SPR in the context of that inquiry, the issues were not exactly the same, but SPR in the context of that inquiry were also objecting to the costs of ongoing litigation. Is CWP's position here not just that they are jumping on that bandwagon which was started by the SPR?
No.
And is this not just a case of Community Wind Power refusing to accept the long-term consequences of its development for the airport?
No, I think the common position with both applications and both inquiries is that both applicants recognise that Glasgow Prestwick Airport is in possession of a wind farm tolerant radar, and therefore both parties disagreed fundamentally, on a technical basis and on a commercial basis as well, because Glasgow Prestwick is asking for an amount of money which is considered to be unreasonable. But fundamentally, Glasgow Prestwick has a wind farm tolerant radar, and both applicants recognise that the mitigation that is required is de minimis. It's limited to the steps that we've set out. That's the commonality between both applications.
Well, there obviously in both cases matters to be determined by the report, or to be reported upon by a reporter, and to be determined by the Scottish ministers ultimately.
That is correct.
Yes. Okay, thank you very much, Mr. Thompson. I have no further questions for you.
Thank you, Mr. Brown. Mr. Thompson, just bear with me a moment. I want to go through my questions. I think the vast majority of them have been answered during the course of cross-examination, but I just want to make sure that I haven't got any that I would still want to ask. One question which has perhaps kind of come to mind during the course of that is, you'll be aware that the applicants shared a proposed condition in terms of mitigation measures and payments relating to Glasgow Prestwick Airport's mitigation requirements. Did you have an input into that condition?
I oversaw that in association with our legal counsel and our external solicitors.
Do you see there to be, so I asked Mr. Parkinson this morning about kind of the scope for things going wrong, so planning for kind of a worst case scenario and the potential sort of reasonableness of that. Is there I suppose, a commercial risk of having some kind of contingency? I'm not thinking in terms of contingency funds, but a contingency sort of mechanism where if the predictions and the evidence ultimately turns out to be incorrect, whether or not the applicant is sufficiently liable or responsible for any mitigation that would be arising from such a circumstance.
Well, obviously, the evidence of Mr. Parkinson is that that risk is negligible. And I think his evidence was that you can never eliminate risk in anything. I'm sure the airport is unable to eliminate all risks from its activities. It just has to operate within the regulatory environment and the risk threshold set out by the CAA. My concern with a condition that went further than that proposed by the applicant is that it would be uncertain as to any timing, any cost, who would be the arbiter of that, any suspensive association or any suspensive element to it. I don't think it's necessary or proportionate or would meet the test of the circular, which is why we've proposed the condition that we have.
Okay, thank you. So, thank you, Mr. Thompson. I don't have any more questions for you. So, Mr. Hardy, would you like to re-examine Mr. Thompson?
Yes, thank you. It's 58. I've got 2 points, hopefully 2 minutes. Then we can go for lunch. So the first of those, if you could turn to the inquiry statement of Glasgow Prestwick Airport, please, Mr. Thompson. There was a question asked very early on in your cross-examination about evidence that had been given at Clauchrie as to the purpose of payments. Do you remember there was a discussion about whether that was CapEx or OpEx or whatever? Yep.
Yeah.
If you could turn to internal page 12, that's paragraph 34 of the GPA statement. Could you just read that to yourself?
Sorry, have you got the electronic document reference there?
It is I'm looking at a hard copy document. It's the GPA inquiry statement, and it's internal paragraph 34.
Yes, on the DPA website. I'll get it on the DPA website.
I think it's in there's a section headed inquiry statements and any statements. Do you have that?
Yeah, I've got inquiry.
Do you have it?
No, not yet, I'm afraid.
It's going to be an anticlimax, I suspect, after all of this. Jake. I mean, I obviously don't want to lead, but at the same time, just for speed, it is what it is. If I could read it, is that quicker?
That's absolutely fine, Mr. Hardy.
Right.
Yeah.
Okay. Paragraph 34, wind farm mitigation agreements. The airport, in keeping with the practice of other airports and ANSPs, has entered into wind farm mitigation agreements with developers of wind farms. Those agreements have resulted in payments being made. However, until recently, they were one-off payments for the lifetime of the developments to which they related. Now that the airport has installed a WFRMS, it recognises that a different approach is appropriate. It therefore proposes that the applicant should enter into a wind farm mitigation agreement which obliges the applicant to pay annual recurring charges to compensate the airport for the costs and risks which it bears. Given that the information contained in those agreements is commercially sensitive and it's entered into similar wind farm agreements with other developers which are covered by obligations of confidentiality, it would be wrong for the airport to make the terms and contents of such agreements available in a public forum such as the inquiry. So if that had been in front of you and you'd read it, the question was going to be this. Does that tell you anything about what the airport wants to do with the money?
Yeah, it just wants to keep it, profit. It's for the long term to inverted commas compensate it for risks that it supposes it has over the duration of the operational life of the wind farm.
Thank you. And that's obviously in the inquiry statement. So that's that point. I hesitate to open this up, but in the email exchange, there was questions about emails and confidentiality. I wonder whether you could go to CD 19.89. So that's in the Glasgow Prestwick Airport documents.
Yeah. Yep.
Do you have that? And then there's an email, well, a couple of emails, but it's an email from Mr. Campbell to Douglas Blythe. It's on the 2nd or
10th of September.
Yes. Could you just read that email to yourself while everyone else reads it?
Which one was it? What date?
So this is the email from Mr. Campbell to Mr. Douglas Blythe at Denton's 10th of September. It's to 1426.
Yeah, that's what I think it is.
Yeah.
Mr. Brown, you've got your microphone turned on. I don't think you were raising something, but I caught something. Thank you.
My apologies, sir. When I lifted up the document, it just accidentally hit the mic.
No, that's fine.
Thank you. Speaker, thank you for pointing that out.
Have you read that, Mr. Thompson?
Yeah, so this is the covering email that I didn't think was in evidence, but this is where we set out that we would be happy to receive an offer on a response on a without prejudice basis.
And your mind reading, I haven't even asked the question, but that was going to be it. The point was whether or not there was in evidence, and I think it was put to you by the advocate that it wasn't in evidence, and you're hearing it. All right.
Yeah, thanks for reminding me.
Thank you very much. Those are the 2 points in re-examination that I want to do with, sir. Thank you.
Thank you, Mr. Hardy. Thank you, Mr. Thompson. We'll now break for lunch. I would propose that we reconvene at 2 p.m. And that will be for Mr. Hardy to call his third witness, Mr. Bell. So again, when we break, Mr. Thompson, you're free to speak to people. You'll be glad to know. You finished just in time. Please don't leave the call. Just close your video down and turn it on mute, and I'll see you again at 2 p.m.
Thank you very much.
Thank you.
Mr. Brown, sorry.
Sorry, sir, can I ask a question about arrangements for this afternoon? We've got Mr. Bell's evidence this afternoon on the basis that well, our friend might be an hour or so with him, and I might be the same in cross, and you may have questions for him, sir, and then re-examination. That may well take us to about 4:30, and that would then be the close of the applicant's case, and my first witness would be Mr. Thompson from the airport. The reason for interjecting is to inquire whether a view can be taken at this stage about whether we require Mr. Thompson this afternoon and whether he can stand down.
Thank you. Yeah, my view and my expectation from today would be that we would hear witnesses 2 and 3 for the applicant, and I'm content to stop there. I think it might be asking a bit much of all parties to then have a third witness today. So I think let's work on the basis that your first witness will start tomorrow morning, please, Mr. Brown.
Thank you very much for that clarification, sir. That's helpful.
I absolutely, I hear that. Just to say, I don't think I'm going to be as long as that with Mr. Bell. That doesn't take away from the point that we can still draw stumps early when Mr. Bell's given his evidence. But I don't want it to be that decision to be made on the basis it'll be a full hour from me. So I suspect it'll be 40 minutes.
That's fine. That doesn't change.
It doesn't change the decision. No, exactly. I just didn't want to be making that decision on false pretenses. Thank you.
No, that's fine. Thank you. Okay. I'll see you again at 2 p.m.
Thank you.
Thank you.
Right.
Good afternoon, everyone. Just going to see if everybody is back at their desks.
Good afternoon, sir.
Good afternoon. Right, I can see. There we go. I can see Mr. Bell. Good afternoon, Mr. Bell.
Good afternoon, Lou.
Okay, Mr. Brown. Sorry, Mr. Hardy. If you'd like to call your third witness as and when you're ready, thank you.
Thank you very much. Then, Mr. Bell, similar drill to the others. You have a precognition. I'm going to ask you to read that to introduce yourself to the inquiry. Section 1 of your precognition, qualifications and experience. Could you read that, please?
Good afternoon. My name is David Bell. I hold a first-class Bachelor of Science honours degree in Town and Country Planning from Heriot-Watt University and a diploma in Urban Design from the University of Strathclyde. I'm a corporate member of the Royal Town Planning Institute and the Chartered Institute of Highways and Transportation. I've over 30 years' experience in planning and development. I established David Bell Planning as a specialist planning consultancy in 2019, having previously been director and head of planning with Jones Lang LaSalle for almost 20 years. Before that, I held positions with Halcrow Fox, Gillespie's and Shankland Cox. I've acted as a witness on planning issues in over 100 public inquiries for various land use types, including inquiries in relation to wind farms and transmission infrastructure under Section 36 and 37 of the Electricity Act, for projects in Scotland, England and Wales. I've also acted as a planning witness in a number of planning appeals and Section 36 cases, which have been heard by way of a hearing procedure. I've extensive experience of advising on renewable energy developments throughout the UK.
Thank you very much. I'm obviously going to hear from you later in proceedings and on matters of policy and energy policy, Mr. Bell, but that's good to introduce you to the inquiry. Section 2 then, scope of evidence, could you read?
The applicant's inquiry statement provided notice that the evidence would be led on the following points. Glasgow Prestwick Airport, GPA's response to the applicant's radar report places considerable emphasis on purported future long-term costs and risks to GPA and states that wind farm developers should compensate GPA for the impacts which they cause for the lifetime of their respective wind farms. Secondly, future risk identified by GPA as a consideration in the applicant's view, which should be given very little weight, absent GPA being able to articulate and quantify the actual additional activities and costs to be incurred and how such activities and costs would be attributable to the existence of the proposed development. Thirdly, GPA's proposed condition is unlawful and contrary to Scottish Government guidance, in particular Circular 498, and should not be attached to a consent for the proposed development. And fourthly, GPA's approach to mitigation is contrary to the relevant statements of policy, including in relation to wind energy and aviation interests as set out in CAP 764 and the Scottish Government's onshore wind policy statement. This scope is set against the background of conclusions made in the applicant's detailed inquiry report, which presents an assessment of the specific impact on GPA operations of the potential issues highlighted by GPA in its inquiry statement. It concludes there is no evidence that any of these issues would have a material impact on the operations of GPA or the ability of the Thermoscanter 4002 to meet and exceed industry standard performance requirements. Therefore, there is no residual operational impact or adverse impacts in the airspace above or in the vicinity of the proposed development. The limited mitigation which is proposed is to meet the specific and identifiable costs of testing and optimization as set out in the Aegis radar report, and nothing further than that.
Thank you. And then section 3, policy response, dealing first of all with the non-material matters and the appropriate approach to planning conditions.
The future risk identified by GPA is not a material planning consideration, or at least is not one which should be given any weight absent GPA being able to articulate what the risk actually is now the Thermoscanter 4002 has been procured. I consider GPA as incorrect in its notion or assumption that a new development should compensate existing developments for theoretical and unquantified future risks of the interaction between the two. This approach would place the burden unfairly on the new development to provide mitigation for any conceivable future scenario, however unlikely or unquantifiable. Furthermore, GPA does not enjoy an absolute ownership right over the airspace proposed to be occupied by the wind turbines, nor is it reasonable or correct that it can make absolute demands of the wind farm. Instead, GPA has the same right as other interested parties, namely that the planning system will consider the land use planning impact on its development of the proposed wind farm. As Section 3ZA1 of the Town and Country Planning Scotland Act 1997, as amended by the 2019 Act, tells us, the purpose of planning is to manage the development and use of land in the long-term public interest. This necessarily involves a balance in the public interest, weighing up material planning considerations. It is not the case that existing developments can exercise a veto over new developments unless their every demand is met. Planning conditions can be imposed and should be to make an otherwise unacceptable development acceptable. But as noted above, the future unspecified risk as articulated by GPA is not a material planning consideration which would make the wind farm otherwise unacceptable. This position is reinforced by the long established position that conditions must be necessary, relevant to planning and the proposed development in question, enforceable, precise and reasonable as per the circular. The circular sets out in paragraph 3 that, quote, conditions should be used to achieve a specific end, not to cover every eventuality, and that, quote, conditions imposed in an unreasonable way so that it proves impracticable or inexpedient to enforce them will damage confidence and should be avoided. A mitigation services agreement providing large sums for unquantified future risks is not necessary, related to the development, nor would it be precise or reasonable. To impose such a condition would not be in accordance with planning policy and conditions, nor should it be contained in a planning obligation. The applicant's proposed mitigation is limited to that which is reasonable, which is to meet the specific and identifiable costs of testing and adaptation set out in the Aegis radar report, and nothing further. The proposed mechanism is a condition requiring the applicant to enter into a binding undertaking to pay for such defined and limited mitigation. I note and take comfort from the fact that such condition is similar to that proposed by SPR at the end of the recent Clauchrie wind farm public inquiry. Such a mechanism prevents GPA from commercially exploiting its ability to withhold approval unless its terms are met, and effectively removes the possibility of an unacceptable ransom situation. It is also relevant that GPA considers its approach to mitigation for future risks to be commercially confidential and negotiable. This suggests that it views its position as having leverage, for example, like a property right, to exploit commercially, rather than a position where it is exposed to an impact which is material and must be mitigated and which should be transparent in the land use planning system. The GPA proposed conditions would not meet the policy tests, and nor would they comply with guidance. Legal submissions are not a matter for me, but the unlawfulness of the GPA approach will be addressed in closing submissions. I find it helpful to think of a simple analogy to capture the above. If an applicant applied for planning permission, for example, for a noisy new development, then it may need to provide or pay for triple glazing for a neighbouring residential property under a planning condition. However, it would not be reasonable to require an applicant to pay a sum as mitigation now towards the risk that if the residential property was to be extended in the future, there may be additional costs of triple glazing which would not otherwise be required. The same sort of logic applies here in this situation.
Thank you very much. And then in the next section, starting at 312, you do with national policy considerations.
This approach is also to some extent reflected in Scottish planning policy, which makes it clear that the precautionary principle should, quote, not be used to impede development without justification. The onshore wind policy statement sets out paragraph 64 that the Scottish Government remains committed to working with airports, radar operators and the wind industry in order to pursue and develop a more strategic approach to mitigating impact of wind development on civil aviation radar. It adds that wind farms are no longer the new and unexpected feature that they once were, and are an established part of Scotland's landscape. And it quotes, given this, we expect in the longer term a move on the part of the air navigation industry towards self-management of this issue. This could be achieved through the deployment of wind farm tolerant radar or other technical solutions. In the shorter term, we will support any strategic use of radar. As set out in the applicant's inquiry report, the Thermoscanter 4002 can accommodate the proposed development without any adverse impact on meeting GPA's operational requirements. This is entirely consistent with the policy approach in the onshore wind policy statement and would meet government expectations on radar solutions. In terms of CAP 764, CEA policy and guidelines on wind turbines, the statement at page 8 is of some relevance. It states, quote, both wind energy and aviation are important to UK national interests, and both industries have legitimate interests that must be balanced carefully. Therefore, it is important that the aviation community recognises the government aspiration for wind turbine development to play an increasing role in the national economy. As such, the aviation community must engage positively in the process of developing solutions to potential conflicts of interest between wind energy and aviation operations. In a similar vein, wind turbine developers must understand the potential impact of developments on aviation, both at a local and a national level, and to fully engage with the aviation industry to develop suitable mitigation solutions. Those involved in addressing wind energy and aviation issues must do so in a positive, cooperative and informed manner. Whilst the aims and interests of the respective industries must be protected, a realistic and pragmatic approach is essential for resolving any conflicts between the government's energy, transport and defence policies. Excuse me. The government's most recent policy position on renewable energy is one of increasing support, making it clear that the expansion of onshore wind is vital to the attainment of targets. The applicant's technical assessments have provided a confident understanding of the potential impacts of the development, and appropriate mitigation is proposed. The applicant's proposed mechanism for control is reasonable and pragmatic and consistent with the approach government expects as per CAP 764 in my view.
Section 4 then, the need case.
Finally, my hearing statement for covering the wider ambit of policy sets out the need case for the proposed development in some detail. The Scottish Government and Scottish Green Party agreed a formal cooperation agreement for the next 5 years of government in August 21. A shared policy programme entitled the Bute House Agreement was published, which sets out areas of mutual policy interest, including energy and planning. This publication was issued in advance of a formal programme of government, which was published in September this year. The document therefore provides the latest insight into the government's approach to both energy and national planning policy. Key points of relevance include the following. In terms of energy, it states that the parties will set an ambition to deliver, subject to consultation, between 8 and 12 gigawatts of additional installed onshore wind by 2030. This will be supported by changes in the planning system needed to permit the growth of this essential zero carbon sector. At the present time, Scotland has approximately 8.4 gigawatts of installed onshore wind capacity. Therefore, the government is looking at a minimum to double this installed capacity in just less than 10 years. In terms of planning, the agreement states that the parties will, amongst other matters, actively enable renewable energy, supporting repowering of existing wind farms and planning for expansion of grid. This further insight into the latest policy approach by government further supports the conclusions in the planning appraisal in my hearing statement, namely that the need case for the development and the benefits arising should be afforded great weight. In my opinion, the approach of GPA would impede rather than enable renewable energy in the context of this application, and that is a further factor justifying rejection of the GPA approach to proposed conditions. The applicant's position is, in my view, sufficiently clear without taking into account national policy and need, but these considerations in any event add further weight to the applicant's position.
Thank you very much, and that takes you to section 5, then your conclusions, 2 short paragraphs. Could you read those?
On this basis, I respectively invite the reporter to accept my evidence and conclusions that no weight should be placed on the position set out by GPA in relation to future risk matters and the way that that has been framed in the proposed draft condition. The applicant has set out an appropriate approach to secure limited and defined mitigation by means of a binding undertaking. Such a condition and resulting mitigation would be consistent with government guidance and policy and should be preferred for the reasons set out. Thank you.
Thank you very much. Now, some limited matters by way of supplementary questions. The first of those, Mr. Bell, is in relation to Clauchrie and at 3.8 of your precognition, you say that you note and take comfort from the fact that such conditions similar to that proposed by SPR at Clauchrie. Were you involved in the Clauchrie inquiry?
Yes, I gave planning evidence for SPR at that inquiry.
Thank you. And were you involved in the policy and condition session at that inquiry?
Yes, I covered the majority of conditions, but the other legal advisors referred specifically to the aviation conditions, but I was aware of that.
So when you speak about Clauchrie, that's from first-hand experience of being there as a witness?
That's correct, yes.
Thank you. Right. The meat of this is really the difference between the conditions that are in play, and I want to look at those in some detail. Have you got copies, Mr. Bell, of the proposed condition from the applicant that was circulated last Friday, I think at 15:45, and then a copy of the proposed condition from GPA?
Yes, I do.
Thank you very much. In essence, as you say in your precognition, there's a limited and discrete amount of mitigation, and the applicant's suggested contents of its obligation. That is what the applicant says is referable. The GPA condition reads that there should be no commencement of development unless the company has entered into a wind farm mitigation WMA with the operator and then submitted the wind farm mitigation scheme and so on. So what I want you to do, applying your knowledge, clearly you're not a lawyer and you make that very plain, but you are experienced as a planner. So from a planning consultant's perspective, I'd like you to assess the GPA proposed condition against the circular and regulatory tests.
Thank you. Yes, I think in terms of the GPA condition, I would have a number of observations on that. In particular, the first point I would say is that it sets out that the developer cannot commence development until it has entered into a WMA, a wind farm mitigation agreement with GPA. Now, I would note that the WMA is a separate obligation to the Wind Farm Mitigation Scheme, or WMS. And the effect is that really GPA is asking the Scottish ministers through this approach, a statutory decision maker, to impose a condition as part of what is a statutory consent under the Electricity Act, and a very public consenting process that requires a developer to enter into a contract with a private company before the developer can commence development. Now, that to me would be an express grant by a public authority of allowing a veto over a development which had otherwise been granted consent and been deemed acceptable by the Scottish ministers to a private company, unless that private company's commercial interests were satisfied. So only if the developer agrees to the commercial terms of GPA, WMA, i.e. the Wind Farm Mitigation Agreement, could the development proceed. And I think it cannot be reasonable, in my view, that a condition grants such a commercial veto to a private company. In effect, it, put simply, allows GPA to name its terms. Mr. Thompson covered that, earlier in his evidence as to, a number of reasons why that was not acceptable. Noting again that if I can use the acronyms, the WMS, the mitigation agreement, and the WMA for the agreement with the WMS are distinct obligations. They don't cross-refer, and there is nothing to relate any payments under the WMA to costs under the WMS. I think the concerns I have are reinforced when the definition of the WMA in the notes to the condition are considered, it refers to negotiation. But the developer cannot proceed other than on terms set out by GPA. And it refers to GPA being compensated. So I think that that approach engages several of the condition tests, certainly necessity, relation to planning and the development in question, precision and reasonableness. Another way of looking at this beyond that sort of forensic analysis is to step back and say, would the Scottish ministers really propose to impose a condition in a Electricity Act consent that says a developer can only proceed if you sign a commercial contract on the terms required by a commercial company or by a private company, and also the ministers don't need to see that WMA at all. It can remain entirely secret, and a view cannot then be formed as to whether that approach is reasonable. And that, in my view, would not be acceptable. So I think that hopefully is a helpful critique of that condition and why I don't think it would satisfy the terms of the circular.
That's very helpful, Mr. Bell. One final question is in relation to the doggedness of the airport in saying we are not prepared to disclose the terms of the wind farm mitigation agreement unless an NDA is entered into. So you've got that sort of closed system. And of course, that it's entitled to do that. But the position one would expect it to take at this inquiry is, come what may, we are not going to tell the reporter what the WMA would consist of. Now, in terms of your knowledge and applying the tests, where does that leave a reporter in being asked to impose a condition when the terms of what would be in that agreement aren't known because the airport is not going to disclose them as a point of principle?
I mean, I just find it quite astounding. This is not a negotiation between two private parties for goods and services where one might expect that to be legitimate. But we are operating in the land use planning system in the public interest. And in my experience, when I've been several years ago dealing with whether it's housing developments and the need for extensions to wastewater treatment works or things like that, more standard infrastructure, there has been a transparency about any necessary sums directly related to a proposed development. There hasn't been secrecy, which from the public process. So that is a key difference and a problem with that approach.
Thank you very much. Same question as a sweeping up position. Is there anything else that you'd like to add? Those are the points I wanted to deal with by way of supplementary questions, Mr. Bell, but if not, then there'll be cross-examination.
No, that's fine, thank you.
Thank you very much. That's evidence in chief then, sir. Thank you.
Thank you, Mr. Hardy. Mr. Brown, when you're ready, please.
Thank you, sir. Mr. Bell, good afternoon.
Good afternoon.
My first questions for you, Mr. Bell, are about your qualifications and experience here. You have said that in paragraph 1.3, you've been a planning, so you've acted as a witness on planning issues in over 100 public inquiries for various land use types. You're obviously a consultant planner, but can I check, you're not an aviation consultant, are you?
No, I'm not. My corporate membership is in the Institute of Highways and Transportation that covers aviation as well. But my main experience has been not in the aviation sector in a technical capacity.
Yeah, and you don't have any experience in operating an airport, do you?
No.
You're not a radar engineer, are you?
No.
And you're not an air traffic controller?
I think that's clearly evident.
Yeah. Now, when you came to prepare your report, you referred to a document which is CAP WIN-370-3, which is a CD reference 13, CD 13 stop 2. Now, when you were preparing your report and you were considering the fact the airport was subject to the regulation of the CAA, were you aware of the difference between being an aerodrome and being an air navigation services provider?
No, I didn't go into that detail.
Okay, so if I put it to you that being an aerodrome, and we'll hear evidence on this from Mr. Thompson, but in essence, when reference is made into the regulatory regime to the aerodrome, it's referring to the building, which is the airport essentially, and the facilities associated with it, and that when it's referring to an air navigation services provider, what the regulations are doing is referring to the fact that there may be the delivery of air traffic services by an air navigation services provider. And I'll come back to that point later, but you weren't aware of that distinction when you prepared your report?
No, I didn't review and apply that in my precognition. No.
Thank you. And when it comes to the question of the airspace, were you aware of the government initiative, which is the Air Modernisation Strategy, which is to be found in CAP 1711, which is CD reference 13.6?
No, I didn't cover that. I'm sure Mr. Parkinson would have been aware of and taken that into account in his evidence.
Okay, well, if I was to take you to that document, it's CD 13.6, and just ask you to have a look at page 5 of the document.
Okay, one issue I've realised this morning is my documents are online, and I'm not entirely sure that if I lose you, if I go off this page,
all right,
to see that document.
Well, on that basis, I'm happy to read it because it's just a few sentences. If
I would appreciate that if that's okay with my counsel. Yep, thank you.
Yes, and if that's acceptable to you, sir, as well.
Yeah, that's fine. It might be. I'm just wondering whether that's going to be a issue as we progress, Mr. Bell. If you're not able to view the documents.
What I can do is I can get a laptop set up beside me, which I should. My apologies, I should have done that. So if there are a lot of other documents to come, I
have a few policy documents, sir.
I've got a number here on my iPad anyway. You know, the ones I assumed were coming up: CAP 764, the circular, SPP, or WPS, and so on. But if there's any other more remote ones, then I'd probably better get my laptop up. My apologies.
Mr. Hardy.
I think, Mr. Bell, you just need to open a new tab. I don't think it's a separate laptop, or there might be a bit of toggling between the two. I hope that's helpful. So
yeah, I mean, I think you will be able to do that. I appreciate that if you've only got one screen in front of you, Mr. Bell, then you can only see one thing at each time.
No, I've got two screens. That's fine.
All right. Okay. Well, it should. Yeah. Well, I'm no IT expert, but I think you should be able to see.
Yeah.
Okay. So sorry for this interruption. If I just type into the browser, does that take me to what I need to see?
As long as you don't close down the WebEx meeting window, keep that open whether it's minimized or not, you should be able to do whatever else you need to.
Okay, it's just saying, do you want to leave this site at the moment if I do that?
I'm not going to advise you on the answer.
That sounded like a Teflon pass to me to advise you to press the button or not, Mr. Bell.
I think let's progress. Mr. Brown, if you're happy to read out that passage, and if we get to a point where it's clearly problematic, we'll take a 5 minute.
Just 3-4 minutes. That's all I need to get it up and running.
Okay. Is that okay, Mr. Brown?
Yes, sir. I'm perfectly happy to read. to read it because it is just a few short passages here from the CAB document 1711, which is the airspace modernisation strategy, and it's page 5, and it's the executive summary, and it's paragraph 1, and it says there, Mr. Bell, and I'm quite happy to take it at dictation speed if you want to write it down so you can see it. It says there, airspace is a crucial.
You could go a bit faster, Mr. Brown, that's fine, I'll get the gist.
Airspace is a crucial part of the UK's infrastructure. It must be maintained and enhanced to provide more choice and value for consumers. And that was the part I was going to put to you there. And the question to you was, when you prepared your report, did you take that into account as part of the policy regime which applies to an airport?
No, I didn't take that specific quote into account, but what I take in the round really is with reference to the two policy documents I mentioned, that CAP 764 and the OWPS. I mean, they both clearly say that there's a need for respect of both parties in terms of ensuring that there is clearly safe airspace. And that continues to function and be fit for purpose, and that the wind industry can coexist and develop. So I fully appreciate that airspace responsibility is there. And as I say, that would have been a backdrop to Mr. Parkinson's evidence as well.
Yeah, so you just to be clear about that, then you've looked at CAP 764, and you may have seen my cross-examination of Mr. Thompson earlier today, but
yep.
I put to him, as you'll recall, it from CAP 764, paragraph 1.3, which it was that at all times responsibility for the provision of safe services lies with the ATS provider or the air navigation service provider. So you're quite happy with that as a proposition?
Yes, I heard that. That's fine.
Yeah, and in paragraph 1.4, with reference to the theme which you have picked up earlier about, and I'll just read it for convenience. Wind turbine developments in aviation need to coexist in order for the UK to achieve its binding European target to achieve a 15% renewable energy commitment by 2020 and enhance energy security. And that's obviously out of date now, whilst meeting national and international transport policies. However, safety in the air is paramount and will not be compromised. And you're quite happy to accept that proposition?
Absolutely, absolutely, yes.
Yeah, and in paragraph 1.5 on page 15, and this is actually dealing with obligations on the aerodrome, and this is the point which I think you weren't aware of earlier, that there's actually a distinction between an aerodrome and an air navigation services provider.
Well, I know they are clearly two distinct matters, and clearly the aerodrome gives rise to specific matters such as the ILS approach and so on. And the air traffic service provider will have a wider responsibility within the airspace.
Yes, okay. Well, and if we're looking for at least a general reference to the obligations on the aerodrome, we would find that in paragraph 1.5, where it says that aerodrome operators are required to have procedures for safeguarding, to monitor the changes in the obstacle environment, marking and lighting and in human activities or land use on the aerodrome and in the areas around the aerodrome. In addition, a requirement is placed on the licensee to take all reasonable steps to ensure that the aerodrome and surrounding airspace are safe at all times for use by aircraft. And you're happy to accept that as a policy by the CAA as well?
Yes.
And if I can ask you to turn to page 18. And it's paragraph 122. And this is actually a reference to various steps which the service provider must take, and it's talking about a service provider here. So in 122, just to get the feel for it, where a service provider has to make changes to equipment or operational procedures in order to safely accommodate a wind turbine development, then the following must be addressed. And it sets out a list of things which have to be taken into account. And it says in 5 that ANSPs that fail to properly address the effects of a wind turbine development on a service may have the existing certificate withdrawn by the CAA or variations applied to the designation which may result in the closure of that service. So are you happy to accept from that, that is quite clear from the sections we've looked at, that the CAA has a very clear expectation of what an ANSP and an aerodrome must do when there's a proposed wind farm, which will have an effect on its operations?
Yes, I don't take any issue with what you've read out. I think all the operational procedures and the potential impact of the development on operational procedures was Mr. Parkinson's expertise. It's not my expertise. So I just flag up that caveat.
Yes, of course. Now, in paragraph 3.3, you say there that, starting in the first line, furthermore, GPA does not enjoy an absolute ownership right over the airspace proposed to be occupied by the wind turbines. Now, do you accept that the airport does not lay any claim to ownership of the airspace?
Yes, I think this is a distinction between what I'm trying to convey in my precognition, which is from a planning and commercial property perspective, if you like, rather than necessarily a very precise CAA aviation policy. So what I'm trying to convey is the point about the reasonableness of absolute demands and to help illustrate that point rather than a technical aerospace matter, if you like.
All right. Now, when we move into the third line of that paragraph, you say that GPA has the same right as other interested parties. Now, on that point, is that correct, that the airport has the same right as other interested parties? Is the issue for the airport not that it's licensed to provide air traffic services in the airspace above the site for this particular development?
That is a particular responsibility of the organisation. What I'm drawing attention to is the more rounded point of statutory consultees and other consultees in the planning system and engaging with the development management process objectively, transparently, and for the matters raised to be deemed material or not, and then balanced out in the wider public interest. So that's really the point I'm making there about parties engaging in the planning system.
Yes, so you would accept in all of that, that the airport does have an interest in this airspace in that it's providing services in it.
Absolutely, and I don't seek to reduce the importance of GPA. Some parties will be concerned about rights of way. These are important, but there's clearly a difference between aerospace and air safety and rights of way. They're both material matters, but I fully accept that it's an important consultee position, and that's why a lot of attention has been placed on it and technical investigations to properly and thoroughly investigate the matter of concern.
Right, thank you, Mr. And you go on in that sentence to say that, this is the second last line of paragraph 3.3, the planning system will consider the land use planning impact on its development of the proposed wind farm. And when you refer to its development there, was that a reference to the airport building?
Yes, it's perhaps not well expressed. It could have been better, but that's right.
Yes. So just to be clear about this, the planning system, given that let me start again. The airport, as we've discussed, has two statuses here, if I can put it that way. It's got its status as an aerodrome operator, and it's got its status as an air navigation services provider. So when you have referred to the development, you were thinking...
Sorry, Mr. Brown, I think what I've actually been intending to say there is impact of the development of the proposed wind farm, rather than referring to the airport or aerodrome, if you like. So
right.
Apologies for any confusion, but I think that's what my intention was.
Okay, that's fine. So you are prepared to acknowledge that this isn't necessarily an ownership right for the airport, is what you are prepared to accept. There's also the fact it provides services in that airspace.
Yes, that's correct.
Now, in terms of paragraph 3.4 of your recognition, you refer to the fact that under section 3ZA1 of the 1997 Act, the purpose of planning is to manage the development and use of land in the long-term public interest. And of course, if we're talking about the public interest, would you accept that the public also has an interest in the airspace, in the sense that the airspace should be safe for use?
Yes.
And you don't say that it necessarily involves a balance in the public interest. And you conclude it by saying it's not the case that existing developments can exercise a veto over new developments unless their every demand is met. Now, by inference, is that a suggestion that the airport is purporting to exercise a veto here?
It's a general point I'm making there, but as I referenced in evidence in chief, that's in effect what the condition, the way it's constructed at the moment, would allow for.
Yes, but is the purpose of the condition not ultimately to allow wind farm developments to take place in the vicinity of the airport in a way which means that, first of all, the air space remains safe for use, and secondly, that the burden of the cost and risk of ensuring the airspace is safe for use is not imposed upon the airport?
The whole approach is related to mitigation, is to require an established mitigation that's required in order to make the development acceptable in the context of Prestwick's operations. And that is the approach that's been taken by the applicant, is to scope that out and be as precise as we can be about it, as set out in Mr. Parkinson's evidence. So that would fit, as I say, with the criteria in the circular. And the circular makes it clear, and this is a quote from the circular, it says the Scottish ministers attach great importance to the criteria being met, so that they do not place unreasonable burdens on applicants. So insofar as there might be a burden, the applicant has scoped out the costs associated with the necessary mitigation. And that is what the planning system seeks, not just in this scheme, but in any other development that would give rise to the need for mitigation, so that there's not an unjustifiable burden on applicants.
Yes, and the question which would arise, Mr. Bell, would be how justifiable or not the burden imposed by a condition would be. Is that?
Yes, I mean, clearly the condition, the way it's set out and what it allows for, has to be justifiable based on assessment, appraisal, evidence. That's correct.
Yeah. And in paragraph 3.5, you say the planning conditions can be imposed to make an otherwise unacceptable development acceptable, but as noted above, the future unspecified risk, as articulated by GPA, is not a material planning consideration. Now, when you have made that statement about future unspecified risk, given you're a planning expert and you established that earlier, when you make that assertion of future unspecified risk as articulated by GPA, are you relying upon input from others to allow you to make that statement?
Yes, I am.
Yes, and without beating about the bush, you're relying upon Mr. Parkinson for that?
Yes, Mr. Parkinson and his review of the table provided by GPA that was referenced in his evidence. That's correct.
And it would be open, you would accept, no doubt, for the inquiry here and the Scottish Ministers ultimately to accept that there is future risk for the airport.
Clearly, before this inquiry, there is Mr. Parkinson's view, and I listened carefully to what he said about the matter of future risk, and in particular, he made the point that the terminal was procured after considerable appraisal, and the risk of issues arising would be insignificant. That is the word he used. And incredibly low was another phrase I've got in my notes. So I think what's before the inquiry, and certainly what I rely on, is Mr. Parkinson's position. But it's open to the reporter to come to a different view, of course. But I think what's before the inquiry is quite compelling in that regard. Mr. Parkinson wasn't saying, it's theoretical, there could be, some material issues that arise that are, medium risk. He was not in that territory. So, that is what I rely on in my discussions with him in that regard.
Yes, and you would accept in making that statement this afternoon, Mr. Bell, that you've not yet heard the evidence from the airport's consultants on the risks which the airport faces.
Of course, yes, that's fair.
Yes. Thank you. Now, again, in paragraph 3.8, you have referred here to the applicant's proposed mitigation is limited to that which is reasonable, which is to meet the specific and identifiable costs of testing adaptation set out in the Aegis radar report and nothing further. And you then set out the mechanism requiring CWP to enter into a binding undertaking to pay, and Mr. Hardy took you to that earlier on. Now, again, the question of specific and identifiable costs and so on associated with mitigation. So when we get into that area, again, you would accept that is a matter which the reporter can make a recommendation on to the Scottish Ministers.
Yes.
And if we were to look at the proposed condition, which you have put before, or which the applicant has put before the inquiry, so if you can just pull that up. Sorry, Mr. Yeah.
That's fine.
Yes, yeah, you have it. What the condition starts by saying the developer shall not commence development until the Scottish Ministers are satisfied the developers put in place a binding undertaking to pay the airport operator such sums as are demonstrably and reasonably incurred by the airport operator. Now, that phrase, demonstrably and reasonably incurred, who decides what's demonstrable in that condition?
Well, demonstrably is being examined in a number of planning contexts, in particular in the National Planning Framework in England. And It relates to evidence-based approaches, and so the approach would be demonstrably setting out what is required through an open and transparent approach, and then looking at what are the reasonable costs to be incurred.
Yes, but ultimately the question is who decides what's demonstrable and who decides what's reasonable?
Well, the Scottish ministers need to be satisfied as set out in the condition.
So are you suggesting then on your approach that it would be the Scottish ministers who would decide what is demonstrable and what is reasonable?
Well, the Scottish ministers, by way of the Energy Consent Unit, attach a number of planning Section 36 conditions attached to the Section 36 consent, and they're used to engaging and discharging with the principal conditions rather than those on a deemed planning permission. So there's certainly experience in the civil service to deal with that. And if the documentation is well set out, which I expect it would be, there's the Aegis report for a start, then that material should be relatively easily put together.
Now, you refer there to the experience of the Energy Consents Unit. Are you aware of the Energy Consents Unit having to get involved in making determinations in the aviation sector in this way?
Not in my particular experience. I've not dealt with discharging conditions with the government directly. No.
And when it comes to the question of what's demonstrably and reasonably incurred, is that not going to turn on technical issues about radar performance and air traffic control operations?
It certainly the technical assessment has already been done to identify what these are. I mean, there is clarity on that.
Well, is there, Mr. Bell? Is there clarity? Because
well, the applicant's position is that there is.
Yes, and of course that's the applicant's position, but equally the airport could say that its technical position is clear, and of course that's an issue which is before this inquiry, is that there is a conflict between the applicant's expert evidence and the airport's expert evidence, not only in relation, well, there's the conflict between the applicant and the airport so far as the radar expertise is concerned, and that's quite clear. But of course we've also got, for the airport in this particular inquiry, technical air traffic control evidence as well, which deals with the operational impact.
Yes, I mean, that's not uncommon in an inquiry to have different professional opinions.
Yes, indeed.
Partly why we are here. And
yes.
the evidence is being examined, and the end positions will be set out and recommendations will be made on that.
Yes.
I don't anticipate there being an impasse, and there will be a route set out for the consenting process and associated conditions.
And what, and obviously your condition is not accepted by the airport, but just curious to know what you think the route would be to resolve conflicts and technical evidence which may arise over time between the airport and the applicant on radar and air traffic control.
Well, do you mean in this inquiry context?
Well, let's proceed on the basis that, and again, this is not accepted by the airport, but let's proceed on the basis that permission is granted with your condition attached to it. And there is later a conflict between the airport and the applicant about what is to be demonstrably unreasonably incurred in connection with mitigating the effect of the proposed development here. How is that going to be resolved down the line?
We don't have a vague position on possible mitigation and theoretical mitigation that has yet to be procured. That sometimes occurs. And, you know, in that situation, I think you're right, you might well be in that situation. But we have the benefit here of the airport already having procured radar. We know it's in operation successfully elsewhere. There's a high level of confidence over the performance status of the radar with this development, and the various technical steps to confirm that in practice have been set out and are reflected in the wording of the condition. So I think if I go back to Mr. Parkinson's evidence, which, as I say, was compelling, it wasn't, you know, on balance, this may or may not be the case. He was very clear in the adjectives he used on the situation. So I have high level of confidence. And when you look at the policy guidance around being precautionary and SPP, and when you look at what the circular says about not covering every eventuality and being precise, I think, you know, the applicant has taken a very reasonable and responsible approach to investing in that investigation to allow this position to be now set out of the inquiry to give the decision makers a level of confidence.
Now, if I've interpreted that correctly, Mr. Bell, I think there are two propositions which I'll put to you, which are built into that approach. First of all, the first proposition is that the mitigation will, so far as the term of radar is concerned, the mitigation will always work. Now, the evidence from the airport on this is that that's not guaranteed in that way.
Okay, well, I've not heard that evidence. That's still to come.
Yes.
The evidence that I have seen so far is that Terma is working successfully at the airport. It's working elsewhere. I've not seen any evidence to show that other airports are having any material problems with it. And I won't repeat myself over Mr. Parkinson's evidence, but, you know, clearly if the airport has got evidence that there's a high likelihood that Terma will simply not work in this context, then we will hear it shortly.
Yes, well, I might take issue with the question of whether it has to be a high likelihood, but we'll perhaps reserve this until we've heard Mr. Fido's evidence. So that was the first proposition. The second proposition is that there is no future risk for the airport.
You know, again, this ground has been covered several times in the last couple of days. I think Mr. Parkinson was quite clear in saying, look, you know, it's very fair to say you cannot eradicate all risk, but in the particular circumstances of this case, and he responded to this a number of times in terms of questions as to whether they should be concerned over this matter, and his view was no, this is not theoretical, it's in practice, and the evidential basis is that there would be any failure would be insignificant as an issue, and an unexpected result is incredibly low. Now, that is from a very well qualified technical expert. So for me as a planner, I need to give my position based on that. If Mr. Parkinson was saying otherwise, I might be, you know, agreeing with you on that proposition, but I'm afraid I can't for the reasons I've set out.
Of course. And the other point there, which we've touched upon earlier, is we've not heard Mr. Fido's evidence yet as the airport's technical expert. Would you be prepared to recognise, for the purposes of this afternoon, Mr. Bell, that the proposed condition may actually prove to be problematic in the context of how the ECU, if that's the body you think should deal with this, how the ECU would ultimately determine what was demonstrably unreasonably incurred by the airport?
I just don't see that the issue there, because I think the condition is very clear in its terms. These are well recognised planning terms, and the condition itself is very precise. There's a lot of technical detail that sits behind that. So I'm afraid I don't agree with that.
All right. And of course, when we look at the subparagraphs 1, 2, 3, and 4, which follow on from your general introduction, of course, this condition is restricted only to what might be described as the initial optimisation of TERMA to make sure it can mitigate the effect of the proposal. Is that correct?
I've not referenced any I've not referenced initial. So
yes, you've not. Sorry, you have not. I agree with you on that, Mr. Bell, and I wasn't trying to force you down that route. But what I'm trying to ask is, you are just envisaging that optimization or mitigation takes place once and that's it?
Well, it's the mitigation required in order to make this development acceptable in the context of Prestwick's operations, and that is what I understand it to be able to do.
Yes, and you're not, when this condition is put forward, the applicant is not thinking about any future burdens on the airport beyond the stages 1 to 3 and then stage 4.
Well, Mr. Parkinson did cover that in some detail in terms of his consideration of future context, and he was very clear in his view, as I've set out earlier.
All right, so if the reporter and ultimately the Scottish ministers were to come to a view that there is future risk for the airport, the future burden which will have to be met here, would you accept that the condition as framed at the moment does not address those future burdens?
If that view is taken, that may arise, but I think the question is what mitigation is needed, and that for a land use planning decision, that is the approach that should be taken. So that question's been posed, it's been answered, and that has to be weighed in the public interest against getting on with what is that very urgent need case that we've talked about. So that specification in the condition is what is needed, and that would enable the development to proceed on the basis of the evidence that has been very thoroughly aired so far from certainly the applicant side. Yes.
All right. But would you accept that if the reporter and the Scottish ministers take the view, having heard the airport's evidence that there is an ongoing risk and an ongoing burden here, that the condition which has been proposed by the applicant wouldn't work?
Well, in those circumstances, which I wouldn't support for the reasons I've set out, it may need to be adjusted, but I don't see any reason for doing that.
All right. Now, in paragraph 3.8, you say that the applicant's proposed mitigation is limited to what is reasonable. Now, again, when you make that statement about what's reasonable, I assume from our discussion that you are relying upon Mr. Parkinson's view on that.
Yes.
And in paragraph 3.10, you say that the proposed conditions would not meet the policy tests and nor would they comply with guidance. And when you express that view, that's just your view, is it?
Well, it's not just my view, actually. I mean, I'm not here to give legal advice or give a legal opinion. I appreciate and respect that. But the senior counsel on the Clauchrie scheme in the closing submissions made it very clear that they had no hesitation in saying that the proposed condition by GPA was unlawful. So it's not just me, it's senior counsel in that case. And indeed, we will hear from legal advisors acting for the applicant at the condition session on that. But I would just leave it at that in terms
Right.
of the legal matter.
Well, in that basis, then, if that's a legal matter, and you have acknowledged that legal submissions are not a matter for me, but the unlawfulness of the GPA approach will be addressed in closing submissions. I'll leave it on that basis for the moment, and I'll just ask you to note, sir, that I'll not take my cross further on that point, and instead it will be addressed as Mr. Bell has suggested in legal submissions as well.
Yeah, no, that's helpful. Thank you.
Now, in paragraph 3.11, you cite out an analogy of planning permission for a noisy new Development. If an applicant applied for planning permission for a noisy new development, then it may need to provide or pay for triple glazing for a neighbouring residential property under a planning condition. However, it would not be reasonable to require the applicant to pay a sum as mitigation now towards the risk that if that residual property wants to be extended in the future, there may be additional costs of triple glazing which would not otherwise be required. And you say the same sort of logic applies here. Now, on that analogy, your analogy proceeds, does it not, on the basis that the triple glazed windows would provide the mitigation for the noise which the existing development would hear? Is that correct?
Yes.
Yeah, and it also proceeds on the basis that no other mitigation for that noise is required.
Yes.
And when you look at, or when you put forward that analogy, what I assume you have in mind is that the mitigation is required so as not to injure the amenity for those living in the pre-existing dwelling.
Yes.
Yeah. But is the position of the owner of that house in your analogy not different to that of the airport? And it's different in this respect, is that the owner will not have regulatory obligations with which it must comply. And what I have in mind there, of course, is the fact that the difference here is that the airport has a regulatory obligation to make sure that airspace remains safe at all times.
That is correct. I think that the point I'm making there is that when planning applications are determined in development management, one looks at the effects of a development. Can it be mitigated to make it acceptable proceed? What planners don't do is speculate way into the future about possibilities that might emerge for a neighbouring development. So that is the essence of the analogy that I was trying to convey.
All right, and if we move on to the next page, at page 5 of recognition, you cover here national policy considerations.
Yep.
Now, when you consider the policy considerations here, what we have looked at is you've looked at the renewable energy policies. First of all, so far as the onshore wind policy statement is concerned, and you've obviously looked at the CAP document as well, but what I've noted is that you've not referred to any other policy considerations so far as the airspace is concerned.
Yeah, that is right. I was really leaving the regulatory aspects to Mr. Parkinson, who can better cover that than me, has more expertise in that. What I've tried to do is bring together, three main elements: the OWPS, which dates from 2017, but it's still very, very relevant. The CAP 764 that talks about the increasing role in the economy of wind turbines, but clearly that was well before net zero. But then bringing in the Butte Agreement and the new target. And I think the real point I'm trying to make is that when you look at those in the round, it further illustrates how I think, with respect, how GPA is out of touch with the reality of what policy expects and is driving for. I mean, the issue of climate change, I've said it's not the need case is not carte blanche for every development. But when you look at the reality of what policy expects, it's this positive engagement, not secrecy. It's positive engagement, transparency, and understanding the way in which development can proceed, and that is what the applicant has sought to do through the mitigation approach.
Yes, but you've said there that the airport is, I can't remember if you said out of step or out of touch, but that was certainly the sentiment of it.
Yeah.
But considering that point is the airport has obviously recognised the need for a radar which has wind farm tolerant capabilities built into it, is it not? Is that not a recognition that the airport understands the way policy is shaping up and the fact that it's essential to achieve net zero?
Yes, it absolutely is, and I think that's a very positive step. I think where the issues arise are in some of the related points about the way the condition is formed, and I think the way the applicant framed the condition better enables things to happen in a way that protects both parties' interests, and also in a way in which the consenting regime can accommodate proper consideration of costs, rather than what Mr. Thompson was explaining earlier was a very difficult to justify approach of X £1,000 per megawatt, which that matter was fully aired at Clauchrie, and the same sentiment in terms of the unacceptability of that position was expressed. So that is certainly, in my view, not consistent with the reality of the policy thrusts at the moment, but certainly procuring the radar is, and that's very welcome.
Yes, well, there is another point to that, and the Clauchrie inquiry. Well, you were. I know I was there as well. I know you were there. But if you were there, you would have heard evidence from Mr. Thompson and Ms. Kilpatrick at the airport that they have, as they see it, certainly worked very hard with developers to find solutions, and that they see the mitigation agreement, which, or the variations of them at least, which they've entered into over the years with developers, they see those as being an enabler of the release of
well, quite frankly, the fact that other developers are entered into agreements is of no relevance whatsoever to the lawfulness or appropriateness of the condition in this inquiry.
Yes, but the fact that the point is that Mr. Bell has noted that the airport is not out to block developments of wind farms, is it? As evidenced by the fact that it has a wind farm tolerant radar, or a radar which has the potential to be wind farm tolerant, and it is entering into agreements with developers. It's not a policy on the part of the airport, is it, to try and prevent land being used in the vicinity of the airport for wind farm development?
It may not be a policy, but the actions may result in a similar effect. I mean, if GPA expects to receive payments not necessarily to mitigate, but to provide a commercial gain and comfort on future unspecified risk, I would say that is not legitimate basis on which to receive payments under a planning permission or under a Section 36 consent.
Yeah.
And certainly when that's, there should be no entitlement to do that in a secret way.
Yes, and the question though, that all of that is a question for the inquiry here, is it not?
It is indeed.
Yeah. Now, when you've looked at national policy considerations, did you take into account the fact that so far as aviation is concerned, aviation is a reserved matter?
I didn't reference that, but accept it, yes.
Yes, and sorry, and did you take account of the fact that the UK government's position on this is that mitigation for a development should be paid for by the wind farm developers who stand to benefit commercially?
Sorry, could you just repeat that again, please? Sorry.
I was asking whether you're taking account of the UK government's policy that in regard to the funding of mitigation of wind impacts on radar, the mitigation costs are to be recovered from the wind farm developers who stand to benefit commercially.
That is the approach that's been taken here.
Yes, but of course, the difference here is that you say that there's no, or the applicant at least says here that there is no ongoing requirement for mitigation after the first three steps in the condition.
That is, as set out by Mr. Parkinson in his evidence, yes.
Yes, but the applicant accepts that the UK government's policy is that the cost of mitigation is to be met by the developer.
Mitigation necessary for the development to proceed, yes, to make it acceptable.
Now, in paragraph, when we start to move into the Scottish dimension of this, in paragraph 3.12, you refer to SPP and you refer to paragraph 204 that the precautionary principle should not be used to impede development without justification. Now, of course, the other paragraph which is relevant here to in the context of a wind farm inquiry is paragraph 169, and I can assume, I hope, that we're all familiar enough with that paragraph, given the roles we each have in wind farm inquiries. But of course, you would acknowledge, Mr. Bell, no doubt, that that paragraph, which sets out the considerations which can be taken into account, includes the impact on aviation.
Yes.
Yeah. So the reporter can take that into account.
Absolutely.
Yes. Now, when we come on to the onshore wind policy statement, I'll just get it. It's CD reference number 8.9, and there's maybe no need to go to it because you have quoted the paragraph 64 in your definition. Now, that is written in 2017, and it says that we expect in the longer term a move on the part of the air navigation industry towards self-management of this issue. Would you accept that that was, so far as the Scottish Government can have a policy in this, that that was part of an aspiration to move towards that point?
Yes.
And if we were to look at the letter, again, it's a CD reference number 1992. And this is a letter from Paul Wheelhouse to various stakeholders. Do you have that?
I don't, but again, if you're able to take me to the relevant part, I'll listen carefully.
Yes, well, thanks for
save time.
Yes, well, this is a letter from Paul Wheelhouse to various stakeholders, and I think in actual fact in the Clauchrie inquiry, this letter was also lodged by SPR, so you might have seen it in that context. This was a letter which was sent by Paul Wheelhouse to various stakeholders, including those in the renewable sector and those in the aviation sector, and he said, "I'm aware of the significant ambitions of both the aviation industry and renewable industry to grow and develop within this challenging framework, and consider the best and most effective way to do this is through meaningful collaboration. In particular, the issue of transitioning the responsibility for adopting wind farm tolerant radar to the aviation industry." So it's in particular that last sentence, Mr. Bell, where Paul Wheelhouse said, in particular, the issue of transitioning the responsibility for adopting wind farm tolerant radar to the aviation industry. Now, that's sent in 2019, so that's 2 years after the onshore wind policy statement. And at that stage, would you accept that it's recognised that the transition had not by that stage been made?
It was underway, certainly underway by then. Yeah.
Yeah, it was a work in progress at that point. Would that be a way to describe it?
Well, you could look at the dates when Terma was referenced in taken on Glasgow, Edinburgh. I don't have these dates before me, but it was before 2019, is my understanding.
Yeah, and if we were to look at a document which I'm sure you will be familiar with, which is not in your recognition, but it's CD reference number 1923, which is the update to the climate change plan from December last year.
Yeah.
You'll be familiar with that. And there's a paragraph in that. Again, I'm content to read it, Mr. Bell, if you're happy for me to proceed on that basis.
Yes.
It's page 41, oh, sorry, page 84. And it's also electronic, page 84. And it's paragraph 3.141, where it said the interaction of wind turbines with aviation radar can sometimes present a barrier to development. We will continue to work with aviation, energy and other stakeholders, exploring best practice for collaboration through our Aviation 2030 Vision Task Force, tackling the technical, regulatory and financial barriers, which will ensure that all radars are wind turbine tolerant, neutral, and freeing up much more capacity for development. And so there's reference there to the Aviation 2030 Vision Task Force there. And again, would you accept that as late as December last year, the government was still recognising that this is an ongoing work in progress?
Yes, I mean, to an extent it is in some areas, some airports with their particular issues that they will be having.
Yes, and of course, maybe one of the things which will emerge here is, and I did ask Mr. Parkinson yesterday about the definition of wind turbine tolerant. One of the issues here is that the Clauchrie inquiry and this inquiry has got us to a point where there's been close examination of this issue, and it's emerging that maybe not all of the issues are understood, and that one of the roles for the task force may be to look at those and to identify what the solutions are and how the energy sector and the aviation sector will seek to resolve them going forward.
Well, I mean, that's as a general point you're making there, but we need to bring that into the specifics of the circumstances of this case and the evidence before this inquiry. And one of the matters that was covered in Mr. Parkinson's evidence in chief was uncertainty of risk, amongst others. And he's given his position. I won't repeat that again. So there is a high level of confidence based on the evidence that Mr. Parkinson has seen, and he said that he relies on himself.
Well, that's us getting back into the technical evidence, Mr. Bell, and we've had a discussion about that. I've deferred to Mr. Parkinson's views on that. But my point here is that when it comes to the issue of transitioning responsibility, what's happened is that the Scottish Government has set up a body of the relevant stakeholders to look at how all of the issues will be resolved. And that's an ongoing work in progress even at this point.
Well, that continues, but that is separate from the specifics that we are dealing with here, where actually GPA has been in the vanguard of this and has made very good progress with implementing the radar, such that we're in a position where really we're just optimizing. So that should be to GPA's credit, and is such that it really allows this development to proceed, which is excellent in terms of the government's wider policy landscape.
Is that not taking us back to technical evidence, Mr. Bell? And I was keen that we would go back to that. But so far as the task force is concerned, I think it almost goes without stating, you're not a member of that task force, are you?
No.
So you're not going to be familiar with the work and of that group?
No. Is any detail of the work of that group before the inquiry?
Yes, well, Mr. Thompson will speak to that. So you're not familiar with how the aviation sector feels about this particular issue, are you?
No, I mean, I'm not giving evidence on the views of the aviation sector and how they feel about the ongoing Scottish Government engagement and progress in that regard, no.
Now, so far as your reference to CAP 764 is concerned, you have quoted, sorry, let me just get it in front of me. You've quoted page 8 of CAP 764, which says CD 13.2, and it's really the passage on page 9, which I'm interested in, where it says that those involved in addressing wind energy and aviation issues must do so in a positive, cooperative and informed manner. Whilst the aims and interests of the respective industries must be protected, a realistic and pragmatic approach is essential for resolving any conflict. Now, what in actual fact you say in paragraph 3.16 is that at the end of that paragraph, we can see on page 5 that the applicant's proposed mechanism for control is reasonable and pragmatic and consistent with the approach government expects as per CAP 764. Now, there's just a small point of difference between what's actually said but it might be important, between what's actually said in CAP 764. CAP 764 refers to a realistic and pragmatic approach, and you have referred in your recognition to a reasonable and pragmatic approach. There might not be much on it, but is a wind farm mitigation agreement not realistic and pragmatic? And I say that, I put these propositions to you for comment. First of all, it recognises the cost and risk burden which the airport will incur as both an aerodrome and an ANSP as a result of the proposed development.
What is that cost?
Well, of course, that's a matter, the way the airport is presenting this, between the airport and the developer who comes along from time to time. But in principle, is that not a way of being realistic and pragmatic?
Well, Mr. Thompson has covered this, and I would, rely on the position he set out that X £1,000 per megawatt, whether that's used elsewhere or not, is of whether it's used elsewhere is of no relevance. But the secrecy of the sum, with secrecy of such sums, it's impossible to conclude that any payments would be reasonable, never mind lawful. So, I think that is not a pragmatic approach. It is not transparent, and in my view, in line with CAP 764. It would not be in line with CAP 764. What we have done is understand the potential impacts, but such an approach would not be positive, cooperative, and informed.
But
it certainly wouldn't leave this public inquiry informed, and it wouldn't leave the Scottish ministers informed.
But is the second point, though, that it would enable the renewable energy development to proceed?
Only on, for the reasons I set out as to why the condition wasn't acceptable, only with GPA holding a veto and absolute leverage on any outcome. And on that basis, whilst the development could theoretically proceed, it wouldn't be, in my view, a reasonable approach to take.
Well, of course, the issue there, Mr. Bell, is that there has been no discussion between the applicant yet and the airport about the proposed terms?
Well, I'll leave that for Mr. Thompson's evidence in terms of how the engagement has taken place between the applicant and GPA.
All right. But the other outcome of a wind farm mitigation agreement being entered into, assuming that it can be mutually agreed, is that it allows the wind farm developer or the wind farm development and the airport, both as an aerodrome and an ENSP, to coexist.
Well, the condition proposed by the applicant does the same thing, but is framed in such a way that it is legitimate for the planning system to deal with it that way, and the payments are related to the development and the specific mitigation.
Yes, but is the other issue there not that a mitigation agreement entered into between the parties, assuming the parties can agree, but a mitigation agreement entered into between the parties allows certainty for both parties because they both know what the scope of their respective risks will be as a result of the...
But it's simply not necessary because the condition as drafted by the applicant provides precision and specification on what is necessary and the costs that are attributable to that objectively assessed requirement for mitigation. And that is what the consenting regime looks for. It doesn't look for unquantifiable matters way in the future. It looks for what are the effects of the development that need to be mitigated now in order to make the development acceptable and to proceed. And at the risk of repeating myself again, that is what is proposed.
Well, yes. Well, I was about to put that to you. Of course, your condition proceeds on the basis there is no future cost and risk, in the airport's position on that is different. But if the inquiry was to hold that there was future cost and risk, one of the advantages of a wind farm mitigation agreement would be that it would resolve the any uncertainty, and both parties would know what the arrangement was going forward so far as the cost of mitigation is concerned.
Well, I just don't see that as being any necessary or reasonable in the context of the evidence we have on the specifics in this case.
And the other point, Mr. Bell, would be that given the discussion we had earlier about what is demonstrably and reasonably incurred, and the fact that, as far as you're aware, the ECU does not have experience of getting involved in aviation and air traffic control matters, and as we'll hear, there are so many variables involved in what the consequences would be. Is there not an advantage in leaving it to the parties where we've got an airport and we've got a wind farm developer, to at least giving them the opportunity to discuss the issues and find resolutions to the issues?
No, for the reasons I've set out, that wouldn't be acceptable, giving a private company the effective veto of a development that the ministers deemed acceptable.
All right, and if the condition was to be imposed and it proved unworkable, could the applicant not apply to have that condition removed?
Well, I don't think there's any need to go to that process because the tests have to be met for the conditions, and that would be an unnecessary scenario that wouldn't arise.
Well, I think that's taking us back to the technical evidence, and your position's understood on that. So far as part 4 of your precognition is concerned, the need.
Sorry, Mr. Brown. Sorry to interrupt you mid-flow. I'm just wondering whether that would be a good point to pause and have a short break.
Well, actually, sir, I've only probably got about 5 minutes. This is the very last section.
Okay, no, that's fine. Okay, thank you.
Okay. Now, so far as the need case is concerned, the report, as will perhaps be clear even from our conversation this afternoon, doesn't take issue with the need case as such. But so far as the documents you've referred to are concerned, do either of these documents say that the cost of any adverse impact on the airspace should be met by the aerodrome or an air navigation services for the lifetime of the wind farm development?
They don't say that. No.
And just one final point, in the programme for government, the programme for government on page 64 refers on the right, sorry, sir, it's CD reference 1922, and it's electronic page 64, and it's the second column, and it's the end of the first paragraph, if you're looking for it, sir, where the Scottish Government says that we will also consult on and publish a new onshore wind policy statement in 2022, setting out the vital role that this technology will play in delivering our net zero commitment. And I think we all understand, Mr. Bell, that that would be an update to the onshore wind policy statement in 2017. And my question for you is that we've looked at the policy approach, or the initiatives at least, which the Scottish Government has taken in relation to this transitioning responsibility for wind farm tolling radar. Given there was a statement in the 2017 policy about transitioning that responsibility, and it's been an ongoing work in progress, would the work on the policy statement in 2022 not also be another opportunity for the Scottish Government to review the policy?
It may be. Just don't know. I mean, that would just speculation as to what may be in it.
But it would be an opportunity. Right, thank you very much, Mr. Bell. I've got no further questions.
Welcome, thank you.
Thank you, Mr. Brown. Before I check whether I've got any remaining questions for you, Mr. Bell, Mr. Hardy, how long do you envisage requiring for re-examination? I'm just wondering whether we take a break now briefly, or we push through.
Again, there's nothing that justifies any re-examination, so nothing at all.
Okay, in which case let me just go through my questions, Mr. Bell, and I may have a couple still for you. Just bear with me. Okay. I think how I want to ask you this question, really, in terms of how to frame it. So, I suppose I'm interested in your view on GPA's role in this process, in terms of the relationship between, or the possible tension between GPA being a statutory consultee versus it having commercial interests as well. And I'm interested to kind of explore, what do you see its sort of statutory duties to be in this context, and to what extent GPA is meeting those or failing to meet those duties. Yeah, I'll pause there. There might be some supplementary aspects.
Yep. I mean, it's an interesting question. It's quite unusual to some extent, having a consultee with a very clear public regulatory stance, but a commercial approach as well. And there's this interaction in the planning system, and clearly the duties are relating to, as Mr. Brown was saying, the aerodrome responsibilities and obligations and the airspace. And what I would say is that Mr. Parkinson's technical report has focused in on what these technical matters are. So putting aside the commercial matters, if you like, and the the necessary mitigation has been scoped out and it's been costed. And if one then brings into mix the commercial interests and some of the secrecy angles on it, that's where it gets difficult, because in my experience, whether that's wastewater works or a new road junction or necessary infrastructure to allow a development to proceed, it's been very transparent about what the cost is, how it's to be met, and what technical work would need to be done to put in a new junction or a roundabout or an extension to the wastewater treatment works or a new classroom on a school. These often arise, and I think here we've got clarity around what the duties are, how the mitigation can be put in place to ensure that those duties continue unimpeded, and the condition can be framed up to reflect all that. And the applicant has set out a way forward to allow that to go before the ministers, uncontaminated, if you like, by the or blighted by the commercial matters that really have no place in the planning system and wouldn't be a legitimate basis on which to allow payments, whether it's a planning permission or a Section 36. And that's really what I've tried to convey.
Thank you. So, in terms of your proposed condition, I appreciate we're going to have the chance to kind of forensically consider this in the hearing session if we need to in session 2. But more broadly, in terms of the condition as proposed by the applicant, in order for it to essentially function as intended, what kind of input or information or dialogue would you need from GPA for it to function as intended?
A lot of that has already been scoped out in the technical report. So the various steps include engagement with the airport operator. So there would be clearly engagement through that process of optimizing, validating, and so on.
Are you? I suppose my question is: Are you satisfied that if GPA wasn't content to proceed on the basis of the condition as outlined, as proposed by the applicant, and this is all assuming, if the proposal was consented subject to a condition to that effect, is there a sort of reasonable expectation upon GPA to cooperate at that point with that approach as establishing a consent, or could there be difficulties emerging which might require a different approach to be considered if that was seen as a risk? I suppose that's what I'm getting at.
Yeah, I mean, I think the legal consequences of that I would leave for the condition session, as to what might result. But the sums referred to in the condition relate to those incurred by the airport operator. So there would need to be engagement with the airport operator in progressing those elements of mitigation, and it's assumed that that would be forthcoming.
Yeah, I don't think I'd want to go any further into that at this stage. Thank you, Mr. Bell, on that point. Let me just review the rest of my questions. It's a point that you've been asked about already, and I've noted your answers to it. But in terms of the onshore wind policy statement and this reference to self-management by operators and the wind farm implications. What does a self-managed system ultimately look like? Do you think when will we know it when we see it? Are we seeing it here? That I suppose is my question.
It doesn't go into definition of that, but what page 16 on the OWPS and paragraph 64 says that this could be achieved through the deployment of wind farm tolerant radar. So I think what that's saying is that when a radar is put in place that is wind farm tolerant, then it allows both industries to progress, namely the duties of the airport and the airspace provider can be provided safely as they should be. They're fit for purpose, and the wind energy sector can progress, not just necessarily this development, but other developments as well. So in that regard, it becomes self-managing through that technical solution, through that wind farm tolerant radar, or other possible solutions that might come along. I think maybe that's probably the best I can offer on that. But I think the way that's expressed, this could be achieved through, that's the government giving a clear example, and that indeed is what we benefit from in this case, with that already being in place.
Thank you, Mr. Bell. I don't have any further questions for you.
Okay, thank you very much.
Thank you, Mr. Hardy. I'm just checking. Do you have any follow-up questions? Now that I've asked my questions.
No, I don't think I do. I mean, obviously there are matters arising out of the mechanics of the proposed condition and how that would work, but I suspect that's probably better left until the conditions session. So I'm not going to ask Mr. Bell about those any further now. So far as I'm concerned, that's it. That's the evidence for the applicant.
Okay. Thank you, Mr. Bell. Thanks, Mr. Hardy, Mr. Brown, for today.
Thank you.
That will we'll conclude today's session. As we said earlier on, we won't hear evidence from GPA this afternoon, so we shall leave it there for today, and we'll reconvene at 9:30 in the morning tomorrow. And I'm expecting to hear Glasgow Prestwick Airport's first witness, Mr. Thompson. Are there any questions at all before we break for this evening?
Just one matter from me, and that is yesterday Mr. Brown said that he wanted an offline conversation with me. That didn't take place yesterday, and it may be that he's not got my contact details. So I wonder whether or not if I send my private mobile number to Amy Cornelius, then he can get hold of me in that way. So if there is something to discuss, it may be timely to do that this afternoon before his witness, his first witness is called.
Yes, Mr. Hardy, that would be a good idea since we've got more time this afternoon. I didn't phone last night just because it was such a long day yesterday on the first day, but yes, we should use the time for that this afternoon.
All right, well then I'll email Amy Cornelius and give her my number. Yes,
thank you very much. And sir, I wonder, given that we're breaking early, whether I may prevail upon Callum here to help do a test of the maps and the videos, which will be played in evidence tomorrow to make sure the technology works all right and we're properly set up at this end.
Yeah, well, I'll let Callum speak for himself in a moment. In terms of that, is your intention for the MP4 the radar videos essentially to be played, to be streamed through on the WebEx call, so we don't need to link to them directly ourselves?
Yes, sir. That's the intention, to share the screen to allow that to happen.
I see. Callum, are you there?
Yep, I'm still here. If
Does that
you need me
okay
to run a test call after this, if the people that are going to be sharing are on the call, I can just end live streaming and end the recording, so you could share it on this call, if that would make sense.
Yes. Thank you very much, Callum. Just take 10 minutes for us to get set up.
Yeah, that's no problem. I'll stop live streaming and stop the recording and keep the call open. But that's fine.
Thank you very much.
Well, I'll stay on the call for that purpose as well, so then I'm able to make sure that I can see it too. So if anybody else wants to see whether or not they're able to view that successfully now, then please do feel free to stay on the call. But otherwise, that's us finished for today. Thank you for your contributions, and I'll see you at 9:30 tomorrow.
So can I just before we go, can I just ask what those what the videos and the montages are going to be?
Yes, the videos are the videos which are referred to by Mr. Smith in his recognition, and it's not my intention to ask Mr. Smith to play all of those, but they be played so that he can speak to the particular points of note.
Right, so coming up with Mr. Smith's evidence, Mr.
Yes.
Brown. Yeah, okay, because there are obviously a number of your witnesses have got. There's quite a lot of overlap between repetition in between the witnesses. That a number of them take extracts from various radar screens, and so as long as I know when it's coming, then that's fine. I probably don't need to see the test.
Yes, and the other thing, Mr. Hardy, is Mr. Thompson will speak to his TMZ file with the overlay mapped tomorrow. He's referred to those in his report, and my intention is that they should be shared on screen so he can speak to them.
Right, well, that's fine. I'm not going to ask really many questions about them anyway, but I don't need to stay on the test for that. Thank you.
Okay.
Okay, thank you very much. Just a reminder again that tomorrow it has a separate link to the WebEx call, so please click on the Wednesday's link, otherwise you won't successfully join us, and I'll see you all tomorrow. Thank you.
Thank you very much. Bye-bye. Bye.
Thank you.